2010-05-08, Money, Banking and Trusts, NTT, Nature of Deposits. Start at 0 hours and 40 seconds. Welcome everyone to this Saturday, May 8, 2010 edition of Money, Banking and Trusts by Moving Titles in Commerce. Welcome to NTT's new trust technology, and tonight's show is entitled, NTT and the Nature of Deposits. NTT and the Nature of Deposits. But first, take notice and acknowledgement with agreement that this show and/or documents is private, and not to be construed or relied upon as being legal advice for any individual legal situation or employed for making legal decisions. And you will not use any of this information for making a legal decision or performing a legal procedure, and is not a substitute for legal advice and/or guidance by a licensed attorney. This private show and/or documents are for academic, informational purposes only, to be used at your own risk, without liability to Christian Walters. By accessing or reviewing this show, or using the documents therein, you understand with agreement that, with all rights reserved, without prejudice, Christian Walters is not an attorney licensed to practice law in the state of Florida, or any other state, and has not given legal advice, or accepted fees for legal advice, provided no assistance, advising, or guidance of any kind, for use by non-attorneys or pro se parties in the preparation or use of the therein reference, and has no interest in any issue referenced to it therein, and is not a party to this, or any action arising from, and is only acting as an authorized capacity as liaisons to communications between the parties. By reading and/or using this information you acquire knowledge, and agree that you are not a client of Christian Walters. These documents and show recordings are incomplete and void without this notice agreement being attached herein by reference, and a breach of this agreement. Upon breach of this agreement, the breaching party becomes liable for admiralty commercial damages of $100 million per stultification or impairment per Christian Walters' discretion. Thank you for your understanding. 0:02 and 34 seconds. So again, the title of this show is NTT and Nature of Deposits. Let's maybe define the purpose of this show. There's several different purposes, and one is the court, say, how not to be a defendant, and be in commerce, or how to be a beneficiary with all beneficial rights, all beneficial title, and all beneficial interest through the executing of a trust, a special deposit by claiming and expressing a trust, and the last one, which is probably the biggest, it's probably everybody's the most interested in, is the claiming of the straw man trust account. The claiming of the straw man trust account. Well, I'm here to burst some bubbles and to set some things straight. And I know I'm gonna cause some controversy, but the truth of the matter rests on the facts. And the fact is that none of us have a straw man account. None of us have a CEST trust. None of us have a foreign citius trust, or the birth certificate. What we have is all debtor-creditor relationship. I keep on harping on, you know. Pay particular attention to the relationships that you're forming on a day-by-day basis, moment-by-moment basis. Especially when you are signing your name, because it's the type of relationship that's gonna establish your status and your position in life and how you're holding your estates. There is no CEST trust, Social Security account trust, there is no foreign citius trust, or birth certificate trust. Everything that's being formed today is all under debtor-creditor. Now that may burst some bubbles, but that's the fact. But, on the flip side, there is a remedy to this. The fact that there is no foreign citius trust, or any social security account, CEST trust, is the fact that you never expressed the trust, therefore it is not a trust. It is not a trust. And that brings us into the title of this show, NTT as New Trust Technology, and the Nature of Deposits, because it's what you are doing in commerce is, and everything that is happening today in the public realm is commerce, and all is banking. We keep on saying that all the time, but we never really understood what that meant, because you are making deposits every day. And it's the type of the deposits, or the nature of the deposits, that is causing you to be under a debtor-creditor relationship. So let's get some definitions here, because the two keys to the nature of deposits and NTT is the definitions of what a deposit is, and the definition of relationship. So, let's go to Black's Law and get a definition on relationships. Relationships, Black's Law 8th edition. relationships, Black's Law, relationship, the nature of the association between two or more people, especially a legally recognized association that makes a difference in the participants' legal rights and duties of care. You better be watching the relationships you are forming. Are you forming a debtor-creditor relationship? Are you forming an agency relationship? Are you forming any kind of commercial relationship that has the association with an executor, administrator, or anything typed under commerce, because it's all debtor-creditor relationship? I don't care what you call it. There's only one exception, and that exception is trust. That's the trust relationship versus commerce, and all the other subsequent relationships that come under it. But what relationship are you starting? Is it gonna be trust, or is it gonna be debtor-creditor? One of the two. Now let's go to the definition of deposit. Black's Law definition, 8th edition. We'll lay some groundwork here so we know what we're talking about as to way of terms. Deposit. The act of giving money or other property, to another who promises to preserve it or use it and return it in kind, especially the act of placing money in a bank for safety and convenience. Now, there are two types of deposits that we wanna really talk about. And this is gonna set the path whether or not you're going one direction, like in The Wizard of Oz, or the other direction, like the Scarecrow was pointing to. General deposits. Now, under deposits, definition of a general deposit is a bank deposit of money that is commingled with other depositors' money. 2. A bank deposit that is to the depositor's credit, thus giving the depositor a right to the money and creating a debtor-creditor relationship between the bank and the depositor. Now, definition of special deposit. Special deposit under Black's Law 8th edition, a bank deposit that is made for a specific purpose that is kept separately, and that is to be returned to the depositor. The bank serves as bailey or trustee for a special deposit, also termed specific deposit, and is also known as, aka, a trust deposit. So special deposit versus general deposit. General deposit is commingled with other depositors' money, special deposit is kept separately and is to be returned to the depositor, and it has a trustee over. So those are the two keys to the nature of the deposits. Now we're going to the book Corpus Juris Secundum. We're going to book number 9, and this is a publication of 1996. Under section 12. It's the deposits section. I want to start in section 269, which is general considerations. I'm switching books around here. Alright, section 12, deposits in general, section 269, general considerations. Some sections I'm gonna read verbatim, some places I'm gonna skip around a bit, so I'll try to distinguish between the two. It says that the term deposit has a well-accepted meaning in the banking business. Banking business, we're doing deposits in just about everything we're doing today. We don't realize it. We're making deposits under doing banking. I'm gonna skip down. The term deposit account has been defined as credit maintained by a bank in favor of a depositor. So if you are making some kind of deposit, you've made it. Your deposit is a deposit account. Next paragraph. This is bingo. A deposit may be made the cloak for some other transaction. A deposit may be the cloak for some other transaction such as a payment, say, as credit, or the giving of security, and in such case equity, looking through form to substance, will treat the transaction according to its real nature. Let me read that again. A deposit may be made the cloak for some other transaction such as a payment or the giving of security, and in such case equity, looking through form to substance, will treat the transaction according to its real nature. So what's that mean? This deposit is the cloak for another type of transaction. Could be a payment of your private credit, say, or the giving. And remember when we made a definition of giving? Giving was the transfer of property to another without compensation. And remember giving was one of the ways. It was synonymous with grant. And we're talking into trust terms now. So the giving of a security and in such case equity, and remember equity was where trusts lie solely, and it's going to look through the form. Don't you fill out forms because everything in the public side is form, procedure and process. So the forms that you fill out for these deposits, whether it be, let's see, a checking account, signature card or deposit slips, or whatever forms you're filling out, it's gonna look through the forms to the substance. And remember, The substance is where the real man is. That's the equitable, right title in interest in equity. It's gonna look through the form to the substance, and we'll treat the transaction according to its real nature. Remember the title of the show, NTT and the nature of deposits. What is the real nature of the deposit? Is it a general deposit or is it a special deposit? Because that's going to determine the type of relationship you're in moment by moment, especially when you sign your signature. The primary division of deposits is into general and special deposits. The same deposit cannot be both a general and a special deposit. Do you hear that? The same deposit cannot be both a general and a special deposit. It has to be one or the other. It can't be both. And you get to determine which one it is. But we're all determining the general deposit and we're all under debtor, creditor. And we have no trust because trust is through the special deposits and you're not expressing any trusts. And you have no CESTUEK trust and no foreign situs trust because you've never expressed it. Nobody's ever done it. You set up every stick of evidence under debtor, creditor, and you're classified a defendant and a debtor. Continuing on, a general deposit, which is an ordinary form, is the payment of money into a bank to be repaid on demand, in whole or in part, as called for in any current money, and has been defined as a deposit generally to the credit of the depositor, to be drawn upon by the depositor in the usual course of business, banking business. Ordinarily, a general deposit consists of money which is mingled with other money of a bank, the entire amount forming a single fund from which depositors are paid. Now I'm gonna jump down to section 270, next section, which is relationships. Relationships between bank and depositor in general. So now these are general deposits and this is the general relationship that's set up, and this is per your general deposits. It says that, a general relationship, in general, is the relation between a bank and a depositor. Therein is that of debtor and creditor, at least in the case of general deposits. If you're making a general deposit, you got a debtor-creditor relationship, no ifs, ands or buts, and you are the debtor, period. It says, the relationship between the bank and the depositor therein is that of a debtor-creditor. That's the bingo. Another one, at least in the case of general deposits. Thus the bank acquires title to the money deposited. Now remember, under trust law, the possessory title is the legal title, and the bank has the legal title, or the possession of the money, and they had to say so, but they also have liability. Continuing on, and because the depositor is the debtor for the amount deposited, so that the bank acquires the title to the money deposited and becomes the depositor's debtor for the amount deposited, so that the depositor has a mere chosen action. And a chosen action is an equitable interest, and that is property interest, which remains vested in the depositor. And that could be your special deposit, if it wasn't general. And its following the deposit of money in a bank is in the nature of a chosen action, which is an equitable interest. And equity's always got to do with rights, titles and interest. It has nothing to do with the actual possession, legal title. So the bank is the debtor to the depositor, but the bank acquires the titles. And you, as the depositor, have a beneficial interest, and that's equity. A beneficial interest is equity, and that gives you a chosen action. So, continuing on, in making payments on the depositor's order, the bank pays its own money to as a debtor and not its depositor's money as an agent, and pays its own money rather than specific money of the maker. The bank's obligation is merely to repay the amount due out of its general funds, which you made by general deposit, and it is not contemplated that the identical bills or money deposited shall be returned to the customer. Now in Gilbert's, we're studying the debtor-creditor relationship, but it said there was an exception to the debtor-creditor relationship, and it gave an example when a specific set of money, say $500 in 20s, was given to somebody for deposit, and the specific bills, the specific $20 bills, were never asked back. It was just that they were supposed to give you back $500 and any bill denomination would satisfy that return. That would have been a debtor-creditor relationship if you didn't ask for specific bills back, but if you ask for the exact same bills back, that would be a special deposit, that would be a trust that was formed, and it would not be debtor-creditor. So, out of the general funds, it is not contemplated that the identical bills or money deposited shall be returned to the customer. A deposit, or account, is therefore not actual cash, but a debt or a chosen action and constitutes personal property, an incorporeal, movable and general intangible. There is, however, a difference between the liability of banks to their depositors, and that of the ordinary debtors as their creditors. And the bank can go beyond the ordinary debtor and creditor relationship and submit to the court any controversy over the ownership of the deposit. A deposit differs from an ordinary debt in that, from its very nature, it is consistently subject to the check of the depositor, and is always payable on demand. Big deal. So, if you make a general deposit, now the bank is owner of your funds, and now they can loan it as their money. And that's what they're doing because they have title to it, and they put it in their books as they own it, and they can do what they want with it. They can loan it back out again. All because you didn't make a special deposit, you made a general deposit. Continuing on, since deposits are debtor obligations of the bank incurred to be performed in the state where the bank is located, they are subject to state's dominion. The relationship between the bank and the depositor therein is generally not that of an agent and principal, although it has been said that the bank discharges its obligation as a debtor subject to the rule obtained between principal and agent, and that a bank's authority to receive money on behalf of a customer derives from its authority to act as the customer's agent. The relationship is not that of bailee and bailer, nor that of trustee and beneficiary. Generally, there is no fiduciary or relationship giving rise to a fiduciary or similar duty between the bank and its depositors as discussed supra in section 248, which is under special duty, which was before, which we didn't talk about here, but we could go to there but I'm really not gonna go on to that. So, to sum that up on section 270 there, the relationship is the debtor, creditor with a general deposit, and you give title to a bank under a general deposit, and the bank now holds the title to the money. Now we're gonna jump into a section, 271, which is contract. Contract, and remember, this is the relationship that is by contract, but it states colorable contracts. It says, the relationship between a bank and a depositor is contractual in nature, and is governed by their contract. So again, the relationship between the bank and its depositor is contractual in nature, and is frequently in the nature of an implied contract. The relation of the depositor and banker arises only out of contract, express or implied. And to create the relationship of depositor and depositee, between a bank and the owner of money deposited by another, such deposit must have been made with the consent of the owner, or ratified by the owner. And ratified means the intention is confirmed. The intention is confirmed, ratified. A deposit creates a contract. A signature card constitutes a contract. The contract arising from the transaction evidenced by the bank account is solely between the depositor and the bank, and no privity is created thereby as between the bank and a third person beneficially interested in the funds on deposit. The relationship between the parties is governed by their contract. Let me say that again, the relationship between the parties is governed by their contract. Remember to watch out for the relationships you're forming moment by moment, and they can be implied contracts, especially at the time of signing. The relationship between the parties governs their contract, and everything today is colorable contracts. Forming a relationship. What type of relationship are you forming? Debtor, creditor or trust? The contractual rights of the parties are derived by implication from the banking relationship, unless such rights are modified by the parties. The relationship may be subject of an express or implied contract. An express agreement as to the particular matter will supersede an obligation which would, in the absence of agreement, be implied with respect to such matter. A private agreement between the parties is enforceable. A private agreement between the parties is enforceable, so that the parties have the right to make their own contract. A private agreement between the parties is enforceable, so that the parties have the right to make their own contract. Is that like a contract within a contract? And their relationship may be made subject to any legal agreement which the parties make, provided the contract is not contrary to public policy or to law. Now, public policy is really one type of debtor, creditor, since 1933, without money, and the law is really statutes and codes. Continuing on, and it does not injuriously affect the rights of innocent third parties. Now let me back up a little bit again, and their relationship may be subject to any legal agreement which the parties make, provided the contract is not contrary to public policy or to law, and does not injuriously affect the rights of innocent third parties. Who are those innocent third parties? Those would be the beneficial interests party, beneficiaries, and if they're beneficiaries, they're on a trust. If it's injuriously affecting the rights of this innocent third party, that supersedes public policy or law. So the relationship may be made subject to legal agreement which the parties make, provided the contract is not contrary to public policy or law. But public policy or law can be superseded in the fiction realm by equity, which is the equitable interest of the beneficial interest, the beneficial right and the beneficial title, which takes precedence over public policy or statutes and code law, and does not injuriously affect the right of the innocent third party. So as beneficiaries, and voiding public policy and the law is what happens. Continuing on, next paragraph, absent a contrary agreement, and remember your contrary agreement is gonna be your special deposit agreement. Absent a contrary agreement between the parties, the provisions of Article 4 of the UCC govern the contract and are made part of the contract. So rules and regulations adopted by the bank generally are, or become, a part of the contract. Generally, a written agreement is conclusive of the relationship between the parties. A deposit agreement should be construed against the bank as the preparer of the agreement, and in a case of questionable or doubtful construction, an account agreement should be interpreted in such a way as to make the promises mutually binding on all parties. Unless such a construction is wholly negated by the language used, a bank may be held responsible for breach of its contract with a depositor. And then there's the next section is Adhesion Contract. There's one small paragraph. A deposit agreement may constitute a contract of adhesion, and such a contract is therefore subject to judicial review for unconscionability, which may be found if one of the parties lacked a meaningful choice, and the terms of the contract are unreasonably favorable to the other party. So let's sum up section 271, contract. Here, which is, the relationship between the bank and its depositor is contractual in nature, and is frequently in the nature of an implied contract. And this implied contract is subject to one that's expressed, but if there is no expressed contract you could make a private agreement between the parties, that the parties have a right to make their own contract. And that contract, or that relationship that is established, can be superseding public policy and statutory code law, and thus it is injuriously affecting the rights of an innocent third party held on a special deposit for the beneficial interest of the third party. But absent a contrary agreement, your special deposit agreement, UCC, or debtor, creditor, because UCC is all debtor, creditor, and that's what's governing commerce today under public policy anyway, and that's what's governing statutes and codes, because today public policy is for the embetterment or the speeding up of commerce, so that more commerce can be done, so that more debt could be made, so that more debt is made for the purpose of money, because debt today is money. Welcome to the national debt, which never seems to get diminished, and now you understand why. So now we want to see, maybe, section 284, determination of character of deposits, page 276. Section 284, determination of character of deposits. The character of a deposit is general or special. Let me say that again. The character of a deposit is general or special, and is a question or fact to be determined by the intention of the parties as revealed by their agreement in all circumstances of the particular case involved. And pay particular attention to the word circumstances, important term, because circumstances. We have special circumstances as real people. The bank deposit is ordinarily a general deposit. There is a rebuttable presumption that a deposit is general, and the burden of proof is on the party claiming that a deposit is special. You gotta be claiming trust. You gotta be claiming special deposit. If you don't, you got a general deposit and you got a debtor, creditor relationship. We have never claimed the Sestuike trust. We have never claimed the foreign situs trust. They've all been general deposits, which created a debtor-creditor relationship. We have no evidence anywhere in existence of any kind of a trust. You'll never find it. It does not exist because we never created. It's up to us to create the evidence that shows and can prove that we have a trust, whether it be foreign situs or whether it be Sestuike. None of us has ever done that. Continuing on, in the absence of a specific direction or agreement to the contrary, a deposit is general. In the absence of special direction, that's your special instruction. Special direction, that's your special deposit instruction. In the absence of special direction or agreement to the contrary, it's one or the other. An agreement can be superseded by a special direction. It's one or the other. Special direction or agreement to the contrary. I don't need an agreement. The agreement is the special direction instruction. Keep that in mind. In the absence of a special direction or agreement to the contrary, a deposit is general. A deposit is special only if the money is placed in the bank for the purpose of safekeeping, or on the understanding that the bank shall act as bailee, or if it is made for a specific purpose with special instructions. Special instructions? That's my agreement. That's my contract with special instructions. Continuing on, or an agreement between the bank and the depositor to use the funds for a special purpose. Keep in mind, this may be a court setting. Think about that while we're reading this. An agreement may be manifested by the bank's acceptance of a conditional deposit. If the agreement of the bank to a special deposit is to be implied by its acceptance of a deposit accompanied by written instructions, the writing should set forth, by clear direction, what the bank is required to do. You want to release? Make a special deposit with instructions as your contract. Continuing on, next paragraph. The general or special character of the account is a question of fact, to be determined by the purpose for which the deposit was made, the relationship existing between the depositor and the bank and the intention of the parties as expressed in their contract. Notice those facts there, and those facts are determined for the purpose. Are we talking about elements of a trust? Purpose, parties, intent, purpose for which a deposit is made, the relationship existing between the depositor and the bank, and the intention of the parties as expressed in their contract and as revealed by the facts and the circumstances of the case, such as the words and acts of the parties and their course of business. Their course of business. But remember, I said circumstances. Next paragraph. No, I'm on the last sentence here. The mere size of the deposit standing alone is not an indication that the account is special. Next paragraph. The fact that a deposit is marked special or bears some particular designation is not controlling, nor is the lack of such a designation conclusive. The bank's failure to maintain the segregation of the deposited funds is an indication that the deposit is general. An individual retirement account, established with a bank in accordance with federal tax law, constitutes a special deposit. And now, a section on accounts subject to check. An account subject to check is ordinarily regarded as a general deposit, although the single fact that funds were placed in a checking account is not conclusive of their character as a general deposit. Deposits may, of course, be general, although not carried in a checking account. And now, interest. Crediting of interest on a deposit is an indication that it is general in character, although this factor is not necessarily controlling. The fact that a deposit draws interest, and also is subject to withdrawal, does not make it a special deposit. So, let's sum up this section on 284, the determination of character of the deposit being in agreement that is a special deposit instruction. And remember, we're gonna talk about circumstances, so we wanna go back now to section 280, which is ownership of an account. Section 280. Ownership of account. The right to return of a deposit, or its equivalent, presumably belongs to the person in whose name it is made, although the form of the deposit is not conclusive. The owner of the bank deposit is determined under contract law. The fact that the funds are deposited in a person's name is prima facie evidence that the funds belong to such person. The law presumes that a deposit, or the right to reclaim it, belongs to the person in whose name it is entered, and the bank cannot question such person's right thereto. The bank cannot question such person's right thereto, however such presumption is rebuttable. The credit given on the bank's books is only prima facie evidence of the rights of the person to whom the deposit was credited. Money deposited to the credit of one person, let's say straw man, bank. One person may be shown by the circumstances again, to belong to another. Let me read it again. The money deposited to the credit of one person may be shown by the circumstances to belong to another. Let me read it again a different way. The money deposited to the credit of the straw man, bank may be shown by the circumstances to belong to the real man, beneficiary. Continuing on, the form of the deposit is not controlling, the form of the deposit is not controlling, on the issue of ownership. The form of the contract, the signatory card, does not prove ownership. The form of the deposit is not controlling on the issue of ownership. But let's put it another way. But equity, the substance, is. The form of the deposit is not controlling on the issue of ownership, nor is claimant's failure to sign a deposit slip conclusive on the question of a title to the fund. The ownership, or the real man, beneficiary - the ownership of the bank deposit may be shown to be different from the apparent owner, the straw man, bank who had title. The ownership of the bank deposit may be shown to be different from the apparent ownership imported by the bank book. The purpose of a deposit account card is not the establishment of ownership, right out of corpus juris secundum. The account card is not a contract of ownership, it's a contract of title. Ownership has to do with rights. Rights are in equity. Title is in the bank, but only to guard against payment to an unauthorized person. The purpose of a depository card is not to establish ownership, but only to guard against payment to an unauthorized person. A little earlier they said that the deposit card was a contract. How can that be? Because a contract does not establish ownership, beneficial rights do, or interest or title. Next paragraph. When the issue of the equitable ownership of a bank account arises, relevant factors include the facts surrounding the creation and history of the account, and the source of the fund, and the intent of the depositor, and the nature of the bank transaction with the parties. So we have the facts, creation, history, source, intent and nature. The mere technicalities of the named owner of the account and the formal organization of that entry are not the focus. The bank does not have a duty to inquire as to the origin of funds deposited into accounts. Remember, this is a 2001 edition hereof. Oh. No, this is 1996 here, corpus juris secundum. The ownership of a bank deposit for the purpose of garnishment is considered, corpus juris secundum under garnishments, section 80. The escheat of unclaimed bank deposit is considered under corpus juris secundum, under escheat, section 6. Next section, notice to bank of interest of third party. A third person, that would be the beneficial interest. Persons having title to funds are not divested thereof by another's deposit of the money in a bank having notice of true ownership of the funds, where a third person has a claim in funds held by a bank, or where the funds are deposited as security for the claims of a third person. Remember that third person is beneficial interest. The bank's knowledge of the arrangement alters when there is a claim on the third party. Where the claims of a third person, the bank's knowledge of the arrangement alters to the extent the claim or the security, the debtor-creditor relationship normally exists between the bank and its depositor. Normally you've got a debtor-creditor relationship under a general deposit, but if you've got a third person in here with a beneficial interest, you've got a trust account. You have a trust deposit, and that debtor-creditor relationship goes bye-bye. It alters the arrangement between you and the bank, because now the bank is trustee. They're not title holder. Or, excuse me, they're not interest holder. Excuse me, they're not interest holder. I'm gonna skip the depositor section. And that would end that section. So, summing up section 280, ownership of account, which is, money deposited to the credit of one person may be shown by the circumstances. Now, the circumstances are really special circumstances, to belong to another. The form of the deposit is not controlling, the form is not controlling, on the issue of ownership. The ownership of the bank account may be shown to be different from the apparent ownership imported by the bank. The ownership of the bank account may be shown to be different from the apparent ownership imported by the bank. Now we wanna go to Black's Law. And we wanna go to the definition of special. Black's Law 8th edition, definition of special, number 1, of, or relating to, or designating a species, kind or individual thing. And remember, thing is the res. Something. Number 2 of a statute, rule, etc., etc. Takes in a lot of things there then etc. Designed for a particular purpose. Designed for a particular purpose. Well, I got lots of purposes. Under trust. Usually extraordinary, or extraordinary. Usually extraordinary, or extraordinary. Now I want to talk about, say, special deposit dash special circumstances. So we have special this, and special that as real men and women, and now it says special circumstances. See exigent circumstances under circumstances. So we will jump to circumstances now. Black's Law 8th edition. Circumstances. Circumstance, an accompanying or accessory fact, event or condition, such as a piece of evidence that indicates the probability of an event. So that's the general description or meaning of circumstance. Now we're gonna look under exigent circumstances. Exigent circumstances. Number 1, a situation that demands unusual or immediate action, and that may allow people to circumvent usual procedures. Bingo. This is one of the very few people that you're gonna find times in Black's Law you're going to find that they use the word people. This defines a right, for we the people, real live, flesh and blood people, not persons. It's a situation that demands unusual or immediate action, and that may allow people to circumvent usual procedures. Circumvent usual procedures. Now skipping down. Number 3, evidence is about to be removed or destroyed is one of the examples, and it also says, see special circumstances. So these are circumstances, but they're circumstances which are special. They're exigent circumstances that demand immediate action of the people to circumvent the usual procedures of their form and their contract under public policy and statute and code law. That is the right of we the people. That's circumstances. So, Section 280 was the ownership of the account, where money deposited to the credit of another person may be shown by the circumstances, in other words, the special circumstances, or the exigent circumstances, to belong to another. The form of the deposit is not controlling on the issue of ownership. The ownership of the bank account may be shown to be different from the apparent ownership imported by the bank. So we went through the definition of special. And special circumstances is also aka special deposit, also trust deposit. They're synonymous, so the bingo is the definition of exigent circumstances is the situation that demands unusual or immediate action, and may, and remember, may means must in legal terms, must allow people, not persons, to circumvent usual procedures. Now I wanna go to section 283, which is special deposits. Now, we've covered general deposits. We're going to 283, we're gonna cover special deposits. And you might want to check out section 213 on page 206, which also talks about special deposits. If we have some time, maybe we might do that. But I don't know if we'll have enough time tonight. Special deposits. A special deposit may be defined broadly as a delivery of money, or other property, to a bank for safekeeping and return in kind. Title to the thing deposited remains in the depositor, title to the thing remains in the depositor, and the bank becomes the depositor's agent, bailey or trustee. So you might as well skip agent or bailey, because it's trustee. Bank becomes the depositor's trustee, because we don't want an agency relationship. We don't want a bailey relationship. We want a trustee relationship, a different kind of agency. Because agent and bailey is nothing more than debtor, creditor. We want a trustee relationship, which is trust relationship by special deposit. Now there's gonna find out there's two kinds of special deposits. Special deposit breaks down into two things. I'm gonna jump to another book, book 26b, Depositories, Corpus Juris Secundum, copyright 2001, section 6. It says special and general deposits. These are special versus general deposits. Remember, we just got done with general deposits. We're talking about special deposits. Now, this is a comparison of them both. A special deposit is one in which the identical subject matter deposited must be kept and redelivered. A general deposit, now, is one in which the identical subject matter need not be returned. Notice it talks about subject matter. Subject matter jurisdiction over the property. You are nothing more than property in commerce, and they take jurisdiction over you by the fact that you're under the debtor-creditor relationship. If you get out of the debtor-creditor relationship by special deposit, they don't have subject matter jurisdiction over you. That would be how you get out of court to be the defendant, and that's how you get out of being operating in commerce as being a debtor, because you are beneficiary with beneficiary interest on a trust. And this also explains why the claiming of the straw man trust account was a fallacy, because there was no trust account. We never set one up. We never expressed it to be a trust, therefore it is not. And all the evidence that we create is just debtor-creditor relationship. Now, let's continue on with special deposits. Back into Book 9, Definition. A special deposit is a delivery of property, and that property is really equitable assets. It's a securities, or even money, to the bank for the purpose of having the same safely kept, and the identical thing deposited returned to the depositor. That's one type of special deposit, or for the same specific purpose. That's the second kind of special deposit, such as a deposit discussed in section 286. Not contemplating a credit on a general account. So in other words, it's not a general deposit. It's not debtor-creditor relationship. It's a special deposit. It's either for a return in kind, or it's a specific purpose special deposit. One of the two, but it's not general in nature, and it is not subject to debtor-creditor relationship. It's in equity. Continuing on, and may also be defined as one held for a particular purpose, in identical or equivalent form as when deposited, subject to return at any time, and not commingled by the depository with other funds or assets of the bank. A special deposit is a delivery of either money or chattel to a bank under special agreement. Remember, special agreement is your instruction. Special agreements are, under circumstances, sufficient to create a trust. Let me read that again. Under circumstances, there's that word again, circumstances, sufficient to create a trust. What would these circumstances be? Special deposit. Continuing on, or a deposit accompanied by an agreement that the identical deposit will be returned or paid out for a specific purpose, or a bailment, agency or trust, whereby a bank keeps or transmits the identical property or funds entrusted to it. And now, creation. A special deposit becomes such by specific directions, or agreement, or through circumstances sufficient to create a trust. Remember exigent circumstances here. Exigent circumstances, a situation that demands unusual or immediate action, and must allow people to circumvent usual procedure. General deposit procedures. Back office banking is what we are doing, under special deposit. Everybody wants to know, where is the private back office banking at? Well, it's in trust, and it's by special deposit. Continuing on, or through wrongful deposit, and rests upon a contract, express or implied. The depositor's consent is usually essential to creation of a special deposit. The bank's consent is also required. But, there is a caveat in there, which we went over earlier. And that caveat was by agreement, and that agreement was the special deposit instruction. That is their consent. They can't do otherwise. Now, relationship between bank and depositor. Now, keep in mind, the bank is also a court, aka the court. Relationship between the court and the depositor, or defendant. This is a bingo. There is no debtor and creditor relationship between the bank in which a special deposit is made. Read it again. There is no debtor-creditor relationship between the bank in which a special deposit is made. Bingo, 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 bingo. And its special depositor, their status or relation being that of principal and agent, bailee and bailer, or trustee and cestui trust. We'll skip the bailer, bailee and the agent, principal one. We'll focus in on the trustee and cestui trust, because that's the one we want. It's special. Next paragraph, title to the thing deposited does not pass to the bank, contrary to general deposit, which it does. Title to the thing deposited does not pass to the bank, but remains in the depositor, the latter retaining the right of control and the right of disposition. Thus, the depositor retains title to the thing deposited, and the bank acts as bailee. But in this case it would be trustee. So, make a special deposit under claim and proof of a trust and into the court, which is a bank, then there is no debtor-creditor relationship and you are not the debtor, defendant. Get the picture? The courts are banks and you're the defendant, the debtor, under a general deposit. Next section, segregation. It is ordinarily contemplated that a bank will preserve the identity of the thing deposited by the segregation thereof from other like kinds of money or property, and that the bank shall have no authority to use its business money placed with it on special deposits, and that the bank must, upon demand, return the identical thing deposited. However, it has been held that a deposit of money may still be regarded as special, even though the funds have been mingled with other funds of the bank, so that it is no longer possible to identify the particular bills or coins deposited, as where a sum equivalent to the deposit is to be kept intact for the use of the depositor, and that where money is made subject of a pledge, trust or special deposit, the identity of the particular money delivered need not be preserved in specie by setting it aside as marked bag or package. If a bank has agreed to segregate funds, and has not done so, then the depositor's recourse is a claim for conversion. So, identity is really the essential thing. Identity of the thing is really essential to the thing, and a name is only one of the methods of identifying, or pinning the identity of the essential thing. It's only one. Name is only an identifier. But it's not the name that is the essential thing, it is the identity of the thing or the person. And there are other methods of identifying the identity of the person or the thing, for they are descriptions of persons. And that is, one of the other methods is boundaries, and one of the other ones is public versus private. Public versus private. Public would be a general deposit, and private would be a special deposit. And a special versus general is going to determine your status is the identity that it is identifying who is what is the thing, the estate. Next section, 284, determination of character of deposit. The character of the deposit. The character of a deposit as general or special is a question or fact to be determined by the intention of the parties as revealed by their agreement, and all the circumstances of the particular. There's that word circumstances again. Okay, I'm going to jump ahead because that's a section we did already. Alright, we'll jump to 285. We're gonna jump to change in character of deposit, and keep in mind that the change in character of deposit could be the, aka prison. So, change in character of deposit. Now, the general or special character of a deposit may be changed by mutual agreement of the parties, but not by unilateral action. To change a general deposit into one of special character requires a contract. Remember, a contract is agreement, and agreement is really nothing more than your special instruction on a special deposit. So to change a general deposit, which everybody's been making, so the straw man account has been made under a general deposit. Therefore it is a debtor account. It's not a special deposit. It's not a CESTUK trust or a foreign CETUS trust. To change it from a general deposit into a special deposit is gonna require a contract, which is an agreement, and it's gonna require a special deposit instruction. To continue on, such a change is dependent on the intent of the parties. The fund, at least in legal contemplation, must be withdrawn. Such a change is dependent on the intent of the parties. The fund, at least in legal contemplation, must be withdrawn, and that withdrawn is your release, must be withdrawn from the general deposit and redeposited with, or put back into the private now, taking it out of the public and putting it into the private. We're gonna move the titles, we're gonna merge the titles, so we're gonna be the fund, at least in legal contemplation, must be withdrawn from the general deposit and redeposited with, and accepted by, the bank under a new arrangement. So there must be some acts, and we're gonna do the act. There must be some act to segregate the funds for a particular purpose, because the act we're gonna do is we're gonna put the order in the bank's issuance to its depositor of cashier's check, to the extent of its deposit, does not change their relationship of debtor or creditor, nor make the transaction a special deposit. By agreement between the parties, a deposit, special when made, becomes general in character. A special character of a deposit cannot be changed by factors which fail clearly to show the intent of the parties to treat the deposit as general. If the deposit is made as special, the bank cannot change its character by carrying the account on its books as a general one, and by wrongfully placing into the depositor's credit in a general checking account. You don't want a general checking account, nor will the deposit of a personal item in the fiduciary account change the special character of the latter, nor will the bank's conversion of a special deposit transmute it into a general deposit. The trustee's unauthorized diversion of funds in a special deposit will not alter the character. It has also been held that commingling of funds by the depositor may destroy the special status of an account. So you don't ever want to commingle your funds as a depositor, because you will breach your trust, and you'll be back into the debtor-creditor relationship. Next section, 286. deposits for specific purposes now. Special deposit for depositing and getting it back was one type of special deposit. Now we're talking about the second kind of special deposit, is the type we're gonna be using, which is for the specific purpose. In general, a deposit of money for a particular purpose may, at least in some circumstances, constitute a special deposit or, according to some authorities, a deposit which is neither general nor wholly special. It is not ultra vires for a bank to receive and hold money to be applied to a specific purpose. Now, what does that word ultra vires mean? That means beyond the authority. Beyond the authority. So, let's read that again. It is not beyond the authority for a bank to receive and hold money to be applied to a specific purpose. So because it's per the granted authority of the depositor under special deposit. Continuing on, a specific deposit, or a deposit for a specific purpose, consists in the delivery of money or property to a bank for application to a designated object or a defined purpose, and in the case of money deposited to meet a maturing obligation, or a note delivered for collection. It has been held that when money is placed in an account for a specific or particular purpose, or to be paid to a particular person, a special deposit exists, at least where the special purpose is made known to the bank. However, it has been held that such a deposit is not necessarily special, and may be general, that such a deposit is special only if the bank knew, and look up UCC 1202 is it? Notice, if you mail something out by green card, and they got it and they have a signature card on it, they've had notice. Such a deposit is special only if the bank knew, or should have known, of the purpose, that in the absence of an agreement, such a deposit is general, even if the purpose is known to the bank, that such a deposit becomes trust fund, only if deposited with the understanding that it should be set apart for a particular purpose, and not mingled with other money of the bank, and that, while the acceptance of funds to be held for a specific purpose gives rise to a special deposit, specific purpose connotes that, in holding the funds, the bank itself acts as an agent directly on behalf of the beneficial owner. The intent of the parties is ordinarily determinative of the question of whether or not a deposit constitutes a trust fund. The parties may, by agreement, give to the deposits, which would otherwise be general with special character of trust funds. Mere designation of the bank deposit by a certain name is insufficient of itself to characterize the deposit as a trust fund, or to put the bank on notice that the deposit so designated, but without any agreement or conditions attached as to withdrawal, may be withdrawn only for a specific purpose, although such designation may, in combination with other facts, be sufficient to show a deposit for a special purpose. The mere form of the bank account, as adopted by the owner, is not sufficient to establish a trust. Facts, rather than book entries, or terminology, are controlling. Terminology, debtor, creditor control, or contract. Terminology on a contract is not controlling here. Facts, rather than book entries, or terminology, are controlling on the issue of whether a bank deposit is impressed with a trust. No particular form of words is necessary to create trust relationship between bank and depositor. And that sounds exactly like we talked in section 67 in Gilbert's. We've been talking about that for months. No party in a trust needs to know that a trust is being formed. And that's what this is saying right here in Corpus Juris Secundum. No particular form of words is necessary to create a trust relationship between the bank and the depositor. So really, it's the facts that are controlling, not where it's deposited or the terminology of the security agreement/debtor, creditor contract. Bingo. Continuing on, whether any particular fund is to be considered as held in trust for a specific purpose or treated merely as a deposit creating a relationship of debtor and creditor will depend upon the circumstances, there's that word again, circumstances, of each particular case. Well, I've got exigent circumstances. How about that, Mr. Banker? Continuing on, if a deposit is made as a general deposit, the fact it is made for the purpose of providing a credit which is to be used hereafter for special purpose, does not give it the status of a trust fund in the hands of the bank. Now, next section, nature of non-general deposit for a specific purpose. A deposit for a special purpose not constituting a general deposit has been referred to as special. It has also been held that such a deposit is neither general nor wholly special and that such deposits constitute a distinct class of deposits. Next section, particular deposits, it has been held that an escrow account is a special deposit. However, it has been held that an escrow deposit presumptively creates a debt rather than a trust. An account in which funds are deposited only for the purpose of payment of the business payroll, which purpose is made known to a bank, is special. And now, under distinction - a little note here says, distinctions exist between special deposit and deposit for specific purposes. Since a special deposit creates a relation of bailer, bailee, and entitles bailer to receive back the exact thing deposited, while deposit for specific purposes creates a fiduciary relationship, bingo. And purpose must be fulfilled according to the terms of the agreement of the deposit. You've got them dead down if you've got a special deposit for a specific purpose, and they must do as per the agreement. And you can always get them in agreement because you don't need a contract, because your contract is the special deposit instruction. That is the agreement. That is what they agreed to. They cannot do otherwise. Next section, consequences of treatment as special deposit. Where a deposit for a specific purpose is treated as a special deposit rather than a general deposit. Title to the thing remains in the depositor and the bank becomes the skipping trustee rather than the debtor. Where a deposit is made for a specific purpose is treated as special deposit. The deposit partakes of the nature of special deposits to the extent that the title to the thing deposited remains in the depositor and does not pass to the bank, unless and until applied to the specific purpose. That no relationship of debtor and creditor is created between the bank and depositor, and that the bank becomes the depositor's trustee. In using deposits made for purposes of having them applied to the particular purpose, if the bank, acting as the agent for the depositor, should fail to apply the deposit at all, or should misapply it, it can be recovered as a trust deposit. The agency, which is a relationship, the agency created by the deposit is revocable by the depositor, and at any time before the purpose of the deposit has been accomplished. A deposit made for a specific purpose, and for the benefit of a third person, creates a trust relationship in favor of such third person, and that third person becomes a beneficial interest, or the beneficiary. However, it has also been held that the creation of the special account alone does not create a fiduciary trust relationship between the bank and the third party for whose benefit the account was established. The money or the other property deposited for a special purpose remains the property of the depositor or of the beneficiary of the deposit and, as the case may be, until compliance with the terms of the deposit or modifications thereof by the interested parties, and may not properly be applied by the bank to any purpose other than that designated. The bank must not commingle the funds. Upon failure to devote the deposit to the specified purpose, it should be returned to the depositor. If a depository bank itself uses the money deposited for the special purpose, the bank must, on the happening of the event agreed upon, pay the equivalent of such deposit to the person entitled thereto. A bank receiving a deposit for a specified purpose, and using or permitting its use for a different purpose, is liable therefor, and where it uses it for its own benefit, that which should have been kept for the depositor. Next section 287, Deposits by Fiduciaries, or aka Trustees. The fact that a deposit is one of a trust funds made by a fiduciary does not render it presumptively special in character, and where such deposits are unrestricted, they are ordinarily regarded as general. In such cases, title passes to the bank, and the relationship between the parties is that of debtor and creditor. Skipping down here to diversions, a depositor has a right to tender a deposit for a specific purpose, and if the bank receives such a deposit, the officers of the bank have no right to divert the deposit for other purposes. And now, no merger with general funds. When a customer indicates that a deposit is made for special purpose, the bank, by accepting deposit, agrees to devote the fund to that purpose, and it does not become merged with general funds of the bank, and upon bank's failure to devote such fund to designated purpose, it must be returned to the depositor. So, an unrestricted deposit of funds for a fiduciary is ordinarily regarded as a general character, at least where the bank has no knowledge of the trust character of the funds, and ordinarily creates a debtor-creditor relationship between the bank and the depositor. When the trust funds are deposited, it is ordinarily the trustee and not the beneficiary who is the bank's creditor, and the fact that a deposit is made by a fiduciary is not of itself sufficient to render such deposit a trust fund with the bank as trustee. or to raise presumption that the deposit is special. So when a trustee properly deposits known trust funds in a bank, they are not necessarily impressed with a trust so as to create a new trust relation between the bank and its depositor. Skipping down, where a fiduciary deposit is regarded as general, title of the funds passes to the bank and the relation of debtor, creditor and not that of trustee and cestui trust is created between bank and depositor. The bank is not required to supervise the subsequent distribution of the funds deposited by a fiduciary. Next section, effect of deposit on character of trust funds. Skipping down, while a deposit of trust funds creates a relation of debtor and creditor between the bank and the depositor, such deposit does not change the trust character of the fund. Right of cestui trust to follow trust funds which have been deposited in the bank is discussed in Corpus Juris Secundum under Trusts, sections 437 and 438. Next section 288, Tort liability of bank for receiving deposits. A bank is not liable in tort for allowing a fiduciary to deposit known trust funds to the fiduciary's individual account, but may be liable where the bank is chargeable with knowledge that the transaction may involve a conversion. Skipping down, the fact that the bank permits a fiduciary to deposit known trust funds to the fiduciary's individual account does not of itself impose liability on the bank for conversion, nor constitute a participation by the bank in a subsequent misappropriation of funds by the fiduciary. Skipping down, to charge the bank with knowledge of the trust character of the funds, but also with the knowledge that the transaction does or may involve a conversion, the bank may be held responsible for permitting for a fiduciary to deposit trust funds into the fiduciary's individual account. The UCC provision stating that a purchaser for notice of 102 and 49 seconds has notice of a claim against an instrument when the purchaser has knowledge that a fiduciary has negotiated the instrument in breach of duty, and has been held rendered into a depository bank, taking. And remember, the only one who has the right to take is the beneficiary. The depository bank taking an instrument with such notice liable to the owner of the instrument for negligence. Let's go over the next section 289, public deposits. Where a deposit of public funds in the same of an agent is authorized, the deposit is ordinarily regarded as a general deposit and title passes to the bank, but where the deposit is unauthorized, the deposit is special and title remains in the political subdivision or its representative. Did they ever make any unauthorized deposits for us? Skipping down, where parties so agree, the deposit may be special in character unless otherwise by agreement, which UCC says all the time. The relation of debtor-creditor arises, the account being regarded as a general deposit, and the fact that the account is carried on a particular designation showing the public character of the fund does not make it special, since the bank's knowledge of the source and the purpose of the public funds is insufficient to establish a special deposit. In this case of a known or authorized deposit of public funds, the bank is not a fiduciary, and the funds are no more impressed with the trust than any other general deposit. Where, however, public funds are deposited in violation of the law, the deposit may be treated as a special deposit, although made as a general one. Now that could be used in this particular way. In a violation of the law, let's say statutes and codes, a deposit may be treated as a special deposit, although made as a general one. Now, how could we apply that to different situations? Continuing on, the relationship of debtor and creditor does not arise between the parties, but the funds are impressed with a trust. Skipping, the bank is regarded as trustee or quasi-trustee of the funds. Remember, the bank can be the court. Next paragraph, the bank may also be held a trustee of public funds deposited where it has received the funds for a special purpose. Okay, so let's kinda summarize this. Really, it comes down to how not to be the debtor in any circumstance, because we always want to be the secured party creditor. But you can't be secured party creditor under debtor-creditor relationship. All the rules and regulations are going against you. That's why the success rate is so low under debtor-creditor relationship, because really, trust is running the whole thing. In the court, really, how not to be the defendant is really, not to go into the general deposit and create all these deposits with all our instruments and whatever we're signing our signatures to, which are instruments, and make general deposits with our unrestricted signatures. And under commerce, How to be the beneficiary with all the right. The title and the interest is the same thing as what is in the Declaration of Independence, that God has given us unalienable rights, all the rights. All right, title and interest. Duty and execution of a trust by special deposit, by claiming and expressing the trust. And the last one, the more important one, the one we're all shooting for, the claiming of the straw man trust account. But it's really not claiming it at all. We've never expressed it. It doesn't even exist. We don't even have a STUK trust or a foreign situs trust because we've never expressed it to be a trust. And there is no information for it, nor will there ever be, until we create it. It's up to us to do everything, and we've done nothing. We've created the debtor-creditor relationship by our own signatures and only us. Through withdrawal of the general deposit, can we change it into a STUK, foreign situs trust? You can't get to Kansas Dorothy, directly, only by and through an express trust, by exigent circumstances, by special deposit for a specific purpose. And now, next Tuesday, the next Tuesday call topic will be, the title of the show will be, NTT and Equity. The power of trust. So the special deposit versus the general deposit under 26B of Corpus Juris Secundum, 2006, Section 6. Under depositories again. A special deposit is one in which the identical subject matter deposited must be kept and redelivered, where the versus the general deposit, where a general deposit is one in which the identical subject matter need not be returned. That's because they've got the title to it because you gave it to them. So, the subject matter jurisdiction - everybody's complaining about the subject matter jurisdiction. The subject matter jurisdiction you grant them by giving them a general deposit. If you want to be under the subject matter jurisdiction of the courts, or in the public realm, you must, because of the general deposit, give the title to the bank, and the public realm has subject matter jurisdiction over that title. But to get away from that subject matter jurisdiction, you have to make a special deposit for a specific purpose. So I thank you all for listening to me carrying on and spouting on about this topic, but we've been doing it all wrong all this time and we need to wake up to the facts. We have the keys in our hands, and now if we use it, and we mold it into it, we can gain the remedy. Because there is no remedy at law, your remedy is in equity. Corpus Juris Secundum, Book 90, this is the one on trusts. It says, as the general rule, the rule of equity, that once a trust is created, it is thereafter to be treated as a trust. When have we ever treated any of this stuff as a trust? Therefore, there has been no trust created. So with that, we'll open it up for questions. Press 6. State your name, where you're from. At 1 hour, 8 minutes, 25 seconds. JC, hey Christian. JC here. CW, hey JC. JC, good evening. CW, hey, how are you tonight? JC, good, thanks. Happy Saturday. So on that special deposit making it into the court, let's talk about response and pleadings. Whether you are the petitioner, respondent, plaintiff, defendant. If you're coming in as a native defendant, for your first response of pleading, you wanna probably have some language in there that says, rather than, presenting to the court, you would rather probably say something like, making special deposit into this court, and then, of course, with your restricted signature and such. CW, right. JC, so, the matter though, is you're still putting that into the public, but it's colorable enough that it's not going to breach any trusts. CW, probably not. As long as you can come up with some colorable verbiage that it wouldn't give away the real, true nature. Because that way equity is gonna look through the form to the substance and reveal the true nature, the real nature behind it. So we have to maintain at least enough colorable semblance, and you can use words that are similar that have portable effect into trust terminology, as well as in the debtor-creditor realm. JC, like, special appearance, making special deposit. CW, yeah, because those words, special connotates a privacy, and that, in of itself, is a manifested act of your intent, that you're intending to keep it private. JC, even though you're depositing that onto the record and into the courts and it's a potluck. CW, yes, and who is probably the bank teller on the court? JC, the clerk, probably. CW, probably so. so the special deposit would have to be tendered to her. JC, I would guess that once you deposit that, and you need to deposit that with her, because if she takes that she'll reroute that to the judge, so the judge is like a banker who will be able to look at your deposit-special deposit, and make heads or tails of it. CW, well, then the judge notices. Now he would have to order her to ledger the thing properly, but it's already been tendered to her, unless we can come up with a better thought. Christian. CW, yeah JC. You done? Garbled. CW, it's Floyd. Go ahead. You got something to add? I was just gonna say along that line, when you say, tendered to the court, does that mean you have to put her name in there or can you just put the court in there? CW, depends who the trustee is. If she is the trustee then it's gonna have to be tendered to the trustee. Let's say, when you start a case, you haven't made an appearance yet. CW, let's not get off topic here. Let's give JC time to finish. Save your thought. JC, it's relevant. Save that thought. We can come back to that, because the real issue that's coming in, is just sort of generally, how you going to plead from here forth, and whether that's just a general responsive pleading, or whether you're going to actually try to move the court and direct the court to do something, and that maybe that's based on private documents you submitted, so it becomes a fairly complex matter of operating colorably in the public and moving the court in the private, and getting that court and out in the public while they can make the determination based on what you submit in the private. But I like special deposit, special appearance concept, so let's go back to that in a minute. The other question I had was, moving forward, I mean our main goal has always been to chop the root out, which is gonna be your, correcting your IMF file essentially, bringing you back to beneficiary status and freezing the record. So it seems that, the first thing that we're gonna have to do is maybe we can talk some technical specifics of this, is first claim our trust whether. And that's probably gonna be by taking and claiming your birth certificate and doing all the NTT things that we want to do with it. Now, that's the first step, and that brings the other question is, we only want to move that title to whoever we're going to move that to, whoever the holder of that legal title is if we want to terminate that trust. So it's possible that we might want to just claim it, and then send an order and a directive to the trustee to do something with that. Whether that's just distribute a portion of the funds, or make payment on all the debts, or whatever we want her to do, but not only acknowledging some of the pieces of the work that we talked about. We give those options and it opens a line of communication with that trustee, and I'd like to know if you think that's still, Rios? If, once we do claim our BC, if that's the way we probably still want to send things to in the private, to transfer the units over to the public side? CW, well, I think our model has to be modified from what we've had in the past, because, I agree with what you said to start out with therein forward, except I think we need to back up. So we're missing, like, an underlayment from what you said. And if we back up, everything that we've created has not been a trust, but there are no trusts in existence. There are documents to support a debtor-creditor relationship. Now those documents, they must be withdrawn from the general deposit. So I believe that the first step we need to do is the withdrawal of the general deposit debtor-creditor documents, and to change the general deposit into one of a special deposit, because it says under section 285, change in character of deposit. That's what we want to do. We want to change a general deposit into one of special character requires a contract. Such a change is dependent on the intent of the parties. The fund, at least in legal contemplation, must be withdrawn from the general deposit and redeposited with, and accepted by, the bank under a new arrangement. There must be some act to segregate the funds for that particular purpose. So I think that's what we're missing our step. We must withdraw the special character, or change the general deposit into the special character special deposit by this contract, and that contract is really the special instruction. Then we can do the redeposit. Then we can claim, or we will claim it as we do the redeposit, really, at 1 hour, 14 minutes. 31 seconds. JC, well, in my situation, we could do that with what occurred with me, because I've already claimed the trust. All I have to do is instruct the sheriff to make that into a special deposit. Then I can bring in the trustees and everything else, and the Sestuik trust and everything. CW, yeah, but we still need to do a withdrawal. We need to do a withdrawal from the general deposit debtor-creditor relationship. I think we'll be actually taking it from the public and putting it into the private. We're merging the titles. JC, we have 30 or 40 years of general deposit history out there. CW, yes. JC, so how do you propose in one fell swoop to draw out all the general deposits at 1 hour, 15 minutes, 14 seconds? CW, the IMF file. All the history is in the IMF file. JC, so, technically, you think the first step is to make a directive order to change the IMF file? CW, yes. Withdraw all the general deposits in the IMF and redeposit them under special trust. That will merge everything and change everything all in one swoop. It's a lot simpler than what we thought, and that will gain you access to the accounts at 1 hour, 15 minutes, 46 seconds. JC, then what you're saying is that we don't have to pay off the war debt or anything else. We're just going for the general fund and switching it over to a special deposit. CW, well, changing it from one side, that would be all the general deposits, that would be all the debts. Everything on the general deposit side, under that liability side of the ledger, will be pulled out of there and put in on the other side. And when it goes over to the other side, it's gonna meet the assets and you've merged the titles. JC, yeah, but we don't have the authority to do it for everybody. We can only do it for ourselves. CW, for ourselves. Yes. Right. JC, so, technically then, Christian, do you think that is just a single letter of direction to the Chief Technology Officer of the IRS, who holds the records as the sole member of the DIB, the Data Integrity Board, directing him or her to make the modification to do withdrawal? Voice, wouldn't it be the Commissioner? JC, well, let Christian answer, please. CW, well, I haven't really thought about, what's the steps gonna be to take? But it looks like it's gonna be a whole lot simpler, maybe, than we had on the board before. It looks like we were missing the withdrawal step first with the IMF. JC, who is the holder of all the legal titles? CW, yeah, I think basically. JC, who holds those titles right now? CW, pardon? JC, who holds those titles right now? CW, I don't really care. They're probably scattered all over the place, because everybody that we granted title to was one that we gave it to. Just think of all the signatures that you've signed. Where are they? Well, they're in the hands, and they could have been assigned to who knows who. I don't know where those titles are, but I don't really care. The IRS does. Let them do their job. Does the king worry about going out into the kitchen and preparing his meal step by step by step? No, he just gives the duty to the cook. All right, cook. You're the master record keeper on these files here. Here's what I want done. Go do it. Voice, so it's just a matter of asking the right question. JC, not asking. Telling. CW, yeah. Voice, well, a king could ask if he just wanted the information. If he was asking. CW, yeah, but then he would give an order, and it would be a non-precatory order. Voice, then you could order after that. CW, right. Voice, Christian, could I ask a question? CW, who was that, again? JC, hey. Christian. Thanks. P. One thing I noticed there, one thing Michael claims, and is that we can only do it for ourselves. I wholly disagree that because it's about what we claim and establish by proving, so we can't only do it for ourselves. We can do it for each and every one of us if we wish, if we can make that claim and substantiate that claim. Voice, but you just want to learn how to do it for yourself first probably. AP, well, that's only probably, but let's not work with probables, and let's work with definites. And so anyone can claim on anyone's behalf, and we can establish and prove it. Yeah, but then, garbled. Voice, actually. Actually. P. I was operating on both levels. And it goes without saying. P. It doesn't go without saying at all. It goes with saying, and that's the whole expression. S. Maybe you didn't understand me, then. I'll just how to do it yourself. It's only common sense, man. At 1 hours, 18 minutes, 38 seconds. P. Which is common sense. S. That you have to know how to do it yourself. P. On behalf of someone else. S. I thought it was simple. Anyways, but yeah. You just have to do it. P. It may not be technically to someone else. Co-beneficiary with them. Garbled. Greater than come on. Let Pete talk. Please. I can't hear him. You keep breaking. S. I just want to save some time. Maybe we're on a different track, so this may not be productive conversation. So nothing personal. P. It may be a productive conversation, though. S. I'm not sure I'm understanding then what you're saying. P. Well, what I'm saying is anyone can make a claim, and anyone can establish a substantiation that claim. You can do it on behalf of someone else. That's what I'm saying, or together with someone else. Garbled. CW, they might be able to do it, people. But here's the thing. They could go out and commingle the funds and destroy the whole thing again. Self-responsibility is gonna be a central core issue. The issue here is who can do it. S. Exactly. In 2 different tracks. I was just making the observation. P. Is mute. That's what happened. That is what's happening and what we're trying to change. To make things happen is by claiming and establishing our claim. And we don't have to necessarily do it for ourselves now. That party commingles their funds, you know. S. Are you asking if somebody can do it for us? Or are you talking in the context of us doing it for somebody else? And I understand the general idea of doing it for somebody else. P. In the realm of claims, whatever we can claim and prove is a trust, then it's trust. S. So now we're talking about claims then. P. Yeah, because, for one, professor of something. I can't remember which, but his name is Rupert Sheldrake and he's proven that we're all one, so. That we are all one. S. Okay. That was longer than I thought. Do you know what I was trying to say? P. Yeah, you were saying that probably things can't happen. S. Probably things can happen. P. Can't happen. S. Can't happen. So. P. Yeah, that was the substance of what you were saying, that things can't happen. S. Before you can do a process for someone else, it goes without saying that you have to know to do it for yourself. CW. Let's get back to topic. Yeah. Let's get back to P. If it goes without saying though, why say it? S. I was just speaking on 2 levels. Just practice. I don't know. CW, whether we do it for somebody or whether we don't do it for somebody is not the issue. It is what? And what direction are we gonna use it in, and how are we gonna get there? S. So, Christian. Are you saying in general as far as this account is concerned, that saying you can put in a declaration of intent, or do you need to close the account and start a new one? So I was just. Are you saying that specifically? That was my question. CW, whether we're gonna do that specifically as a declaration and close the account? Is that what you mean? S. Yeah, because you were talking earlier. What did you say now? It was to the effect of, regarding the account, that there has got to be a complete withdrawal, and then, for me to deposit, by special deposit, or something to that effect. CW, yeah, all these account. The no trusts in existence until we create them. So, nobody's created. There's no trust. S. Okay. CW, all those accounts are debtor, creditor accounts. S. CW, all these accounts are debtor, creditor accounts. We gotta change them, withdraw them out of that public realm and put them under special deposit. S. So, like on a practical example. An existing account. Do you think that declaration of intent is going to work, or are you looking at having to shut down that account and open the account completely new, or is the declaration of intent in effect, and basically giving them the instructions to maintain all other non-changed information. For example, CW, well, I think we're kinda jumping ahead too far, based on the information that we've got. S, okay, I just thought maybe that would be, a principle that you'd apply. And how you? CW, in effect, we're terminating the debtor-creditor relationships with all these debtor-creditor accounts. CW, and we're withdrawing them. We're terminating them, so to speak, by withdrawing them. Christian. CW, so that would be like debtor titles under debtor/creditor. We're pulling out those titles and really we're merging them back again with the assets. So it all could be done with notices, and CW, notices. It's basically the same thing we've been talking about all along, except it's a little more clarification. It becomes a little more clearer, exactly what has happened and what we've been doing in the past that we've been doing wrong. And with that knowledge we can say, oh, aha, I see. We gotta do a withdrawal first, which is really the pulling out of the debt titles and merging them with the asset side, and putting them back in under special deposit, which is no more than what we've been talking about all along, except we got a better crystal clear, view of what's going on. What has been happening all along? It's like there are no trusts out there until we create them. There are no debtor-creditor relationships out there either until we create them. But what types of relationships have we create? We're doing it all, so we have to do it. We have to redo it. We have to withdraw, which would be merging the titles, really, and making it a special deposit. Special deposit for a specific purpose. Greater than, yeah, Christian. Could I make a suggestion? CW, yeah, go ahead. Greater than it'd be like going back and correcting a mistake. CW, yeah, which is basically what we've been talking about. We have the right to go back and, correct the trust, but really we're not correcting any trust, because there's no trust in existence to correct. Laughing, that's the problem. We're all looking for evidence of the Sestuik trust. We're all looking for evidence of the birth certificate trust, the foreign situs trust. There is no evidence. None of us has ever found any. That's because there is none. We never created it. At the same time it's full of evidence that we have been. CW, you kind of broke up. I'm saying that at the same time, it's full of evidence of Sestuik, that we are the Sestuik trust and we never claimed it. CW, true, right. Everything now. It's all about the claim and the establishments of that claim. CW, right. Everything now is all about the claim and the establishment of that claim. Be recognized. CW, right, but now we have to. CW, right. And we want to, really, to trust, because trust is special deposit. But we also have to take into account we've got debtor-creditor relationship that we've established. We have to terminate or withdraw those debtor-creditor relationships and merge them with trust relationship. So we definitely can't operate both, then, on any one account. CW, sure, you're in control of everything. You're creating them all. Debtor, creditor or trust. Can you do it back and forth? Or do you just wanna completely be, like do you wanna use? CW, can you do what? Can you back and forth? CW, ever again? I don't have to. Could you not use it to just use debtor, creditor as part of the colorful interpretation, and just get away from that? CW, well, depends on how you're gonna operate, say, debtor, creditor. I don't want to be effectively connected with the United States trade or business. With special deposits, I will never be effectively connected with a trade or business in the United States. So really, it's a state of mind. When you are in a debtor-creditor setup, now you come to that realization that you don't have to be. It goes beyond the terms of the contract, but, CW, yes, like Wizard of Oz, when, Dorothy came into that realm, she was in She killed a witch and was imputed with a debt. There was a charge against her. And it wasn't until later on in the movie, when she liquidated the witch, that she eliminated the charge. She discharged the charge. Now that took care of the debt that was on the public side, and then she could believe, which is trusts, that she had that power all along, and then she realized that, and she could click her heels 3 times, which was the manifestation of the belief, and then she could go home. P. How about this? Whatever debtor-creditor relationship that created the relationship that we got. And you've expressed this before, but all we do is reclaim is claim it as a trust. Withdrawal. And now we're in equity. CW, general deposits are in debtor-creditor and in the land of Oz. P. CW, trusts, special deposits in equity in Kansas. P. Along comes the claim. CW, getting into the position where it's gonna. Let me pull up where it talks about that. P. Is it in Gilbert's? CW, Gilbert's? No, number. I'm thinking of. P. Corpus Juris Secundum. CW, yeah, Corpus Juris was at the beginning when I just started. It said that a deposit may be made the cloak of some other transaction, such as a payment or the giving of security, and, in such case, equity, looking through form, the substance will treat the transaction according to its real nature. I think that that's beautiful. I couldn't say it more eloquently. That really explained everything that's happening. All of these deposits can be the cloak for another type of transaction, a payment for a debt, but only in equity, because only equity can look through the debtor-creditor form to the substance in equity and then treat that transaction as the real nature. P. So if we say that equity, trust, and therefore without making the claim, equity's like a tiger on the grass, and we need to bring that tiger on the grass out on our behalf. CW, equity is where the real power of the trust comes in. It's a 900-pound gorilla. P. Yeah. CW, and equity is I have a right, I have a title, and I have an interest. Because that's what equity is going to enforce. That's where I get my remedy. In equity, there is no adequate remedy at law, and at law is the public side of the court. I had to go into equity to get a remedy, and that's where my P. I was talking to a guy that was in and out of the court and just getting bounced around the court system, been going on for 10 years, and at one point he ended up in the Court of Chancery and got out of there within 2 days, and he never knew why at the time. And I spoke to him, and I was telling him about their, NTT, and he understood why they wanted him out of there. CW, P. Well, now he's gone back in there. CW, it's all about the relationship you're establishing. Are you establishing a debtor-creditor relationship through commerce, or are you establishing an equitable relationship under trusts? P. Well, now, CW, it's all about through commerce, or are you establishing an trusts all the way? CW, you can be in Kansas under trusts, or you can be under Oz, debtor/creditor. Or commerce. I don't ever want to do commerce ever again. Commerce gets you is gonna get you under debtor/creditor. P. I was reading a part in one of the trust books. Can't remember which one. And one part said that equity will see the true sort of relationship of what's going on, whereas law, will miss other parts. CW, right. It has to. CW, yes. This is Michael. With my situation, Michael Tobin made a trust, okay. Now I can't go back into the court system, but what I is with the sheriff, is write him a letter telling him that the third party, which was my wife bringing in the money to get me out, was an interest, and then make that a special deposit and tell him to return the same, and then with the beneficiary being a WCL, which is the beneficiary of that, is my daughter. So I've got 2 people here that are third parties, that are interested parties. CW, right. Because she came on my behalf to pay the money. The thing is, when I wrote like the return the trust trees, they didn't return the trust property, and I wrote that down. And initially when I wrote that down, judge in there, and, of course it was on the public side, I told them that it was a special deposit, so they know all this stuff, I just have to continue expressing it. Now, should I just still continue doing the UCC? And it's already at the county level. CW, yeah, I would say it. This is expressing it more crystal clear understanding, as to the, the picture, of what has actually been happening. And we can simplify it. CW, we can simplify it a little bit better. One thing. Then I basically write him an instruction letter. Trustee, because he took the money, and basically instruct him on what to do. And if he doesn't do it in that point in time, then basically he is in breach of trust and commingling the funds. CW, right. That would be the agreement of the contract that says that they have to do this. Because the instruction for the special deposit would be that contract or agreement. But I don't show him the special deposit, instruction, or do I? Because that's basically the contract. That's what you're saying? CW, well, they don't have to have as actually the contract, because that is the contract. They still have instruction. Because you want to specify for specific purpose. Because special deposit has two characteristics. One was just a regular special deposit, which would be whatever I put it, I get back out. But then the one for the specific purpose, I wanna apply it toward a debt. That's the one that establishes the trustee of fiduciary trustee duty. That actually turns it into a special deposit trust and makes them actually liable, so that contains the contract, the agreement, and what to apply it to. Because what they did is they applied it to the bail, and I want my money back, and I also want my trust property back, which is the fingerprints, everything. CW, so here's a notice to the bank of interest of a third party. It says where a third party has a claim in funds. Or, say, a court, or the sheriff or whoever, or where funds are deposited. For a claim of a third person. The bank's knowledge of the arrangement alters to the extent that the claim or security the debtor, creditor to the extent. So that debtor, creditor relationship has been altered. It now changes to a trust for a special deposit for the specific purpose. What about damages? CW, yeah, I mean, certify a tort action against them or possibly another equity action against him for breaching trust. Then, you've got at law remedy you could go after, which are colorable. And there you'd go for the equity route for breaching the trust. Which is all in court. CW, yeah. The only problem with that is, because I'm not a resident anywhere, I can't file a CW strawman suit. But the strawman has no residence in the state. Please don't interrupt me. I'm talking to CW. What I was thinking of doing, I've created a WCL trust and I was the grantor of that trust, or my real name was the grantor of that trust, and I was thinking I'm making Michael Tobin the beneficiary of the trust, but who is the managing director of the trust is my wife. Reconstrue that where I'd be the trustee of the trust and then go after and file suit on behalf of WCL, on behalf of the beneficiary of Michael Tobin. CW, alright. Say that set up again. Who's the trustee on the account? Well, the beneficiary of the pure banking trust is my daughter, okay. The managing director of that trust is my wife. I was the creator of that trust, okay. So, what, my real name. Now, what I was thinking of doing is bringing Michael Tobin in, putting him down as a beneficiary and then possibly bringing me in, and my real name. The thing is, see, this is where it's going to get real sticky because they know me as Michael Tobin, not in my real name. Court action. And this is what I'm trying to figure out now, how to get round that, because my wife does not have knowledge to do this. CW, keep in mind that the beneficiary does not have to be revealed by the trustee. Never has to be revealed, whoever that party is. CW, now you can be beneficiary on the private. You can be the trustee on the public side. A trustee on the public side can't be forced to reveal who the beneficiary is. Okay, I see what you're saying. So, in other words, myself. Board meeting and appoint Michael Tobin, because that's who they know me by the identifications as a trustee, and then at that point in time, I can go in because WCL would be the beneficiary of this whole thing. CW, right. I mean, you might not have the beneficiaries on the private side anyway. CW, you could change the trustee on the public side. Yeah, because. CW, so my first thing is to instruct the sheriff what he needs to do. If he doesn't do it, then I go ahead and do the next step, which is to file the civil suit. CW, well, the instruction would have to be to the sheriff from who? Which party? Would be from Michael Tobin, the one that was arrested and incarcerated. CW, and what is his office? Grantor. CW, alright. Was there a trust formed already? Is that, or? Trustee would be able to. Well, the trustees was originally formed through qualified signatures during the arrest. CW, okay. Well, I'm thinking that you probably have to set up a trustee change first, and then that new trustee would be able to give an order as trustee to the sheriff. So I would be grantor, trustee, or just trustee. CW, yeah, if that's how you want to play it. But in order to issue an order as trustee, you'd have to be trustee first. Change the position. Can you appoint yourself trustee? I can appoint anybody as trustee. I'm grantor. Remember, you can play all three positions. Sorry, I cut out. Did you say you can? Yes. Cool. So that would be the first move. Yes, I don't want to confuse CW. I'm dealing with two trust. Now, there is no formation was a trust when I was arrested, so I have two trusts here. There's a trust being a beneficiary, and then a trust that was created through my signature. CW, why don't you operate through the one trust that was formed in the court? Okay, and make myself. Of course I don't have to tell them who the beneficiary is. CW, right, because I can just tell them at that point in time you need to pay to this individual, or whoever the case may be. CW, yeah, and whoever, yeah. Okay, I see what you're saying. Don't confuse the whole thing. So I go ahead and do the UCC, move the titles, and bring that in and have that ready for evidence. But at this point in time, when I write to the sheriff, I'm saying that Michael Tobin, being trustee, is instructing you to do this. And if you don't do this, then it could be construed that you're commingling funds and in breach of trust. CW, right, and also damages. I can apply damages at that point in time too. CW, yeah. Okay, I'll let you know what occurs. I'm done with. I hand it over. Good question. CW, hello. I hear somebody in the background there. Hi, this is Albert. CW, hey Albert. How you doing, Christian? CW, long time no see. No, I've been listening for the last month. CW, good. What's your question tonight? Glad to have you on. This is a good show today. But, ask questions. I know my brother's in Ireland, my Levite brother, shalom. Anyways, oh, yeah? And, CW, laughing. Now, I have a question dealing with people I know that want to, divorce, and what they want to do is to write in their property, placing trust of. And I was wondering something like that open up trust to the public? CW, doesn't have to, number. Okay. A constructive trust, there. To cure wrongdoing or to prevent unjust enrichment. I'd ask for about, moving the titles and signatures. What I was wondering about that. What would be considered special trust deposit? CW, whatever their assets are. That would be the special trust deposit. Whose assets? CW, well, you're saying that this couple want to form a trust. I don't know what their assets are. Well, the first question we're dealing with is, they're putting property in trust. You just gave me the answer. CW, yeah, I don't think. Really? CW, I mean, what kind of property do you have? You say we don't have any property. You have spoken about trust. trust property where, it is sold or, to another person, and a constructive trust, envelope and, stated something about when it's a family member, that the courts might consider it a gift, or at least not even state that. But there's a certain way that it can be expressed, like, for instance, when there is consideration given and, consideration can be oral, so, would that be a bona fide trust between family members? CW, yeah? To split up their assets, so they're going to put it as trust jointly. They're going to have to agree to that. Then, of course. Brought up. Tonight you brought up another one. You were talking about special deposit and, CW, yeah? For a specific purpose. That's what I was going to mention next. Okay. Now, the special deposit that I'm getting a rough time and so, would for this one person that I have ... would a special deposit be considered as someone, paying into for either security or for consideration? Would that be considered a special trust deposit, when they have CW? Well, if the elements other and the method of the formation of a trust, and that was trust, yes. Okay. CW, if there was intent, purpose, parties, and specific trust trees and one of the methods of formation, yeah? That would be a trust, that would be a special deposit. And question. When these two people, they're just trying, to move all contract off of themselves ... but at the same time, their intent is, not of any relation to property other than possibly trust for the duration of their lives, and then, the beneficiary or beneficial owner the same person. Does sound, like trustee. CW, yeah, that trustee is going to have to own the whole thing. He'll have possession ... but he'll have to do what's set up in the indenture. Right. The indenture, it doesn't have to be elaborate, type of work, does it? CW, number. It sounds like what you're trying to create is just some kind of asset protection device, like what Carlos was talking about, an inter vivos trust for the purpose of taking the assets and putting them into trust, and so that nobody knows where they are, so they're private. When you were speaking about a bank, and forming a trust, at the very beginning, before you open up an account, what wording can you possibly put on their document? Have a trust formation. But without them knowing. CW, that's a little harder. Yeah, let's come up with tricky verbiage that establishes you have a trust. I give you my pen, but I want my pen, say, within 2 weeks. That was a trust. No trust verbiage was in there even as a trust was being administered. But now if I got a problem with what happens to enforce it, now someone's gonna have to know that there's trust. Well, I guess that one is for the books. CW, yeah? Actually the administration of the trust is going to be a lot of people's problems. They think they're just going to write some indenture and just forget about it, it's going to take care of itself. And I'm afraid you gotta know what you can't do. Mingle your own trust. P. With the bank, and the banker come back and openly said that they are the beneficiary. Yeah, that's really what? CW, yeah, because they're under a general deposit they have title, and under the debtor-creditor relationship, yeah? Well, we got to get into special deposit in such a way that they don't know it, right? They don't know it. CW, yeah? You probably could. It's not like they don't do special deposits. It's just we're not knocking on the right doors when they say, I never heard of that. It's all over the place. You guys never heard of special deposit? Get lost. What the heck's going on here? Is that public-private thing? CW, deposit. As back office banking. Through the front door of the bank and asking them to do a special deposit through the general deposit side. And that's why got denied. Because they can't talking that in the public, right? CW, right. Is that separate? CW, right. Just a quick question. The guy with the divorce. I guess it goes without saying that it's an uncontested divorce, right? Greater than correct. There. Completely. In cooperation with each other. Greater than absolutely. Then are you asking how they do it or can they do it? Well no, I didn't was to ask Chris this question. What the question really points to is, to have there's property where both are going to agree as to where it goes, and I didn't want, them to say something that would open them up, Christian spoke about not putting the trust public. Okay. Oh, I see what you're getting at. Right. How do you do it privately is what you're asking. Yeah. That's addressing to chambers, I think. I don't know. Is that what he's asking, Christian? Basically, how to do the private thing. What kind of procedure should they be partaking? And that should be communication, something like private for judge. That, CW, well, is Carlos on tonight? Carlos. Who is that masked bandit? CW, he speaks of intervivors trusts and how to use those. I don't think there is such a thing as, getting divorce, private, other than having. CW, the divorce would be a public thing, but you could hold your assets in private because prior to the divorce, that your assets would be handled a specific way, privately. And the record of divorce has to be public, right? CW, only. I don't think so, number. When it comes down to the question, do you own anything? We don't own a thing, question mark. You're saying if people get divorced they could do something the titles jointly? CW, sure. Whatever assets that they hold as, jointly, if they're in agreement they could put it in trust. What about their, the original contract of the marriage in the first place, which is a public, registered record? The whole goal is to get rid of that paperwork, so that's a public document. Is there a way to do that? Some kind of, question mark. CW, so that's gonna have to be publicly adjudicated. Yeah, at least it's gonna have to be publicly adjudicated, right? CW, right. I suppose that they should do preventive care and then possibly, do the trust thing first and, and when they go up and cancel the contract they could state in public that we don't own any property. It's all in trust under so and we're holding beneficial title, the equitable title. And, they could say that there's a trust, right? CW, yeah, they could probably do that. Agreement. Are they, is there any intention in maintaining a relationship afterwards, on any level? I didn't ask that. Do you know? No laughing. I didn't want to ask whether or not they're gonna to have relations. But, since they do have children, relationship is a given. You know what I mean? Interesting. Yeah. Maybe two totally rational intelligent people trying to make the best of the situation. CW, yeah. You check into an intervivors trust and, maybe, talk privately with Carlos, and he can give you some clues as to how to set that up. Okay, you think Carlos has been down that road already? CW, yeah. Yes, he has, yeah. I'll talk to Carlos, mi amigo. We're all trying to get to the same place, and it starts with the letter F, unfortunately. And, we must work together, and even though, there's probably, 1,000 ways to skin this cat. This trust that you're teaching, Christian, is absolute until we get to the level where we can get out of corporation and in republic, and that's really, our goal. CW, well, I think the first step is to identify what we've done, and that we've done it all wrong, and then we have to reverse everything that we've done, in exact reversal. Wow. Oh, you're kidding. You could do. That makes perfect sense. Yeah, backwards. CW, and you do a withdrawal and you with a special deposit. It's that simple. You just go back to every contract and get a hold of the people involved with that and start communicating essentially. CW, no, I don't have to go back to every contract. If we go to the individual master file, we can get them all in one fell swoop. Yeah, but where is that, though? CW, it's in the IRS. The IRS got the IMF. Oh, the IMF. Okay, that one specifically. Okay, I was thinking something. Birth certificate. Have you even been listening? You know, you spend most of your time talking and talking over other people and you don't listen to what CW said. He said that earlier when he was talking. Who's this? I'd really appreciate it if you'd start listening. That's a very interesting opinion there, Michael. This is Michael. I gotcha, meow. We're all in the same road and there are no cars driving by. Just ourselves walking. We gotta make all the time constructive, especially Christian, who is sticking his neck out for us. You know, I'd like to know how to change the IMF code myself. I've got special programs that can code a lot of that stuff, but really show me how to change myself from public to private, and, I would really love to learn that. CW, we're just on the verge of implementing that, so hang in there. What's that, Christian? CW, I said we're just on the verge of implementing that, so hang in there. Yeah, I'm hanging. Yeah. You know, all 10 toes. You know, there's been a lot of documents out there talking about, the IMF and, you know, I have my own special life that I have, and I can tell you, a lot of it is disinformation. And I know that there is good information out there, and when you say that, in baby steps, at crossroads, what road are we really on, you know? So that's CW, right. So that's every one of us has a specific trial that they're going through, and some of us have really a lot of the same things at the same time. You know, we got this and we got homes, we got cars, we got children. You know, those things we all have in common. And another thing, the most the best of all, that we are freedom-minded and, you know, because of that we must work together, and, you know, we love. And, you know. For instance, you guys are doing real good. You're allowing me to. Without knocking me down, and I'm glad. We need to work together. It should be mutual. You know, we all need to calm down. Times. And it's just gonna work. CW, well, we all created this life that we have, however many years we've been living. We created a life all based on debtor, creditor. And that's a lot to unwind for a lot of people. And people have no concept of what they've created, how they've created it. But yet it can be all simplified and unwound, all in one fell swoop. And now, if we understand how we've created this mess. We can stay away from how we've created it, and we can stick on the private side, and we don't need to do this commerce thing again. We can interface in, stay out of commerce. Christian, are you saying? There's a Gordian knot there. CW, one fell swoop, one motion, you can eliminate the whole thing. It's a lot simpler than as much depth as I've gone into tonight, because they're looking for something more complex. It's not complex at all. The secret of the hiding it is that it is hidden in simple plain view, and you can't see it because you're looking for something more difficult. Laughing. So, what exactly are we looking at? Laughing. CW, general deposit versus special deposit. It's that simple, and you kill the one by withdrawing it out of the general deposit realm and put it in special deposit, into the trust realm, all in one fell swoop. And I don't mean to sound cliched, but I take it that could be done by special instruction. CW, yeah, right. Interesting. Let the class go on, then. CW, transfer $250 million over to an LLC and then get on with your life. Amen. Now, it's that special deposit that has several, definitions, to me, I mean, so far as what I've learned from you, because there's so many different contracts, and each one has a special deposit definitions in it, but I suppose, you know, generally, it is one definition, but, pertaining area, or, contract you got into, would have to implement differently, correct? CW, well, special deposit breaks down into, there's only two types. There's the special deposit that what you put in you get back out, And then there's the other one that's specifically allocated for specific purpose. And the specific purpose would be for, say, for the payment of any debts or obligations owed under the, say, 1776 law form, for any lawful purpose, under 1776 law form, and for the payment of any debt or obligation of the party, whoever it's meant for, that's, their, beneficiary. A. What kind of success rate on this, Christian? Successful doing this, you know, CW, nobody's done it under trust yet. Absolutely no one. Wow. We're developing it, creating the concepts, process. CW, all along we thought that we were accessing the Sestuik Trust, but the Sestuik Trust does not exist. It does not exist until you bring it into existence. Nobody's brought it into existence. Therefore it does not exist. That's why we can't find any evidence for it in existence. And that's why they can say, hey, I don't see a trust here. They're right. There is no trust. You never created a trust, manifested it as a trust, a Sestuik trust, therefore there is none. You never created a foreign situ's trust, therefore there is none. And we're all looking for the access to get into this thing or trying to write instruments against it. It doesn't exist. It doesn't mean it can't exist. You gotta create it. Once we create it, then it exists. All we've done is created a debtor-creditor relationship. By general deposit and everything we've been doing in our life, we've been doing under general deposit and we've been creating a debtor-creditor relationship and we all debtors because of it. Who's the swoop office? In one fell swoop do this. One fell swoop. Who would be the office that we would work with that would wipe it all out? CW, the IRS. Okay, the IMF codes, right? CW, yes, Okay, I get you now. That certainly changes your status and that's what it's all about. It's status. CW, yeah, they're the record keepers. They know where all those debt titles are, where all that debtor-creditor stuff is. You guys are the accountants. I'm just giving you an order to take all those titles, withdraw them out of the debtor-creditor realm and put them in the other realm, the private realm, by special deposit. And therefore I merge the titles and pay the debt. Bingo. In the act of doing that. CW, all at once. That causes that to happen like that. CW, what was that? You kind of garbled. You said, when you move it in from the public into private, that causes the merging right there, or payment of all the debt. CW, yes. They count all the beans that, there, get into our pockets. So they would know every contract, every signature dealing with, their, Federal Reserve notes, definitely. CW, yes. Get that account terminated, do the disbursement on it, put the disbursement into a fund that I'm going to designate, and would that zero out the whole public side? By definition, CW, yes. All past, present and future debts, gone. Because it goes from public to private. CW, yes. It gets completely removed. Completely remove it from public. CW, yes. Yes, you collapse the trust. You collapse it and then there's no more debt, and then at that point in time, more than likely, if I'm right, we go to Rio's and instruct her what to do. So, Michael, we don't use the word collapse anymore. Right? You don't apostrophe T. Collapse anymore. Terminate. CW, terminate. Or extinguish. CW, extinguish the debts. Terminate the trust. Well, Christian, I'd love to hear that call, where we just focus on that one particular thing. I know you've taught us a lot of trust and it's good for a lot of us because, we've got these different things going on, everybody, but when you focus, the site puts a laser beam on it. That's what it is. That is what? There are 27 participants in this conference. CW, oh, we'll keep on working on it. I was wondering if our brothers over there in Ireland and, do they have same, situation going on too? CW, It's worldwide. It's not just here and over there. It's everywhere. IMF has tentacles that go that far. CW, worldwide. Yeah. Unbelievable. Interesting. Well, guys, this is a huge work for us to do, I see it like this: Christians call, handful of people, whatever, 80. It's still a handful of people compared to popular, okay. Handful of people learn this stuff, teach this stuff, and maybe the next generation will have hope. CW, yeah? Do you think this is similar to a pardon process, in terms of documentation and stuff? CW, similar to a what now? Well, I know a pardon process would be like a request. Be similar, basically asking people in the record department to get a hold of some records, and then you want to give them, whatever documents you gotta create, which can be some kinds of statements and stuff. That It's similar. It reminds me of some kind of statements and stuff. It's similar. Reminds me of the pardon process. And it's like it's got to be with the government, or in this case you're saying the IRS. CW, yeah, but it boils down to the, I forget where it's at now. Financial records. CW, under bills and notes. The documents that are created by the issuer, whoever signed the instruments. That is the owner of the document, and the ownership never ceases. So that's where we gotta focus our study, then. The concept of whose the ownership is. CW, if those documents are always yours, all you have to do is withdraw them from the general deposit you've made. That's the public. So it is true. Anything with your signature on it, you are entitled to get, the original copy of. CW, absolutely. Don't let them tell you any different. You're the sole owner of them. There's no exception to that. CW, no exception. Nope. You are the issuer, you are the owner of the document. That's why they get all fancy-pansy when you start talking about CW. You give it to them, and give means that you transfer title to them without compensation. And we're even shortchanging yourself when we're asking for copies or certified copies. You should just be saying give me the original. CW, yes, they're the debtor to you, because you made the deposit to them. You gave it to them. Oh, man, and then after I get it in my hands I can say here, I'll tell you what, I'll give it back to you. CW, but see, you created the general deposit. Under the general deposit, you created the debtor-creditor relationship, and you're the debtor, and they keep on saying, hey, we don't have to do this, because you're the debtor. You gave us the document. Number come under equity. Oh, right. Okay. Right. CW, come under equity and tell them I want that back because that's mine. Let equity. That's all posturing. That's all postured context and intent. Is that right? CW, it's subject matter jurisdiction. They don't have subject matter jurisdiction over it. Jurisdiction is definitely posturing and intent. CW, yeah, a special versus general deposits here. A special deposit is one in which the identical subject matter deposited must be kept and redelivered. A general deposit is one in which the identical subject matter need not be returned. It's subject matter. It's jurisdiction. You gave them jurisdiction by making a general deposit. Get rid of it as a general deposit by re-expressing it basically as a special deposit. Withdraw it out of the general deposit. Okay, so, just to clarify, just to see if I got this right. There's a huge focus intense psychological party, gotta really keep your focus on this thing. How you're standing and what you're trying to say and communicate to them, because that's what's differentiating it, to make sure you don't keep jumping back and forth and using sloppy language and stuff. CW, yes, right. The special deposit is trust. It's on the private side. The general deposit is the debtor, creditor, and it's on the public side, and we put everything into the public under a general deposit and they have subject matter jurisdiction over it, but we can pull it out of that subject matter jurisdiction by withdrawing it and making a special deposit, putting it back into the private and doing it in a real clear unequivocal straightforward manner, so there's no, possibility to misinterpretation on their part. At 2 hours, 2 minutes, 18 seconds, CW, yes, they're all depositories, and under depositories under corpus juris, under Book 26b, Section 6, is talking about special and general deposits. And it's that definition I just read. A special deposit is one in which the identical subject matter deposited must be kept and redelivered, whereas general deposit is one in which the identical subject matter need not be returned. Why does it need to be returned? Because you never asked for it back. You never ordered it back. Because it was yours all along. Okay, so this is really important, to have our logic clear, so that our communication of what we are doing is very clear, because that's how the argument's always going to be. They're going to say now, see, your debtor, creditor, and then you try to go no, I'm trying to be private in public here. So it gets to that logic and really understanding and seeing. CW, I don't to sit there and argue with the guys that are sitting on the front there under the general deposit. I'm gonna go up higher and tell them, hey, if you're going to breach the trust, I'll be glad to put you into court and settle the matter. Right, so it's a matter like generally speaking, they're going to try and say now your debtor, creditor. You'll just have to hold your ground and say excuse me, there's a definite misunderstanding here because I'm operating in trust, like that, sign it. You know what I mean? Because that's what they're going to be coming from. CW, say again. Are you saying that, in general, the argument is going to be something to the effect of we're going to come at you, sorry your debtor, creditor, so all there, all terminology of the contract applies. And you're going to come out and say no, I think there's a misunderstanding. I'm coming from trust position. And then, CW, right. You really have to understand it, truly understand it. CW, yes, because I made a general deposit. I'm debtor, but I can make a withdrawal at 2 hours, 4 minutes, 7 seconds. CW, because even under debtor, creditor, the ownership, I still am the owner of the document because my name is on it. Right, there you go. Okay, so that's why that's the key concept there. You still have that right of withdrawal, no matter, either way. Is that affirmative there, or, CW, say again, Shane. The principle, the underlying principle that you always have the right of withdrawal, debtor, creditor or the trustee, because that's fundamental. CW, yeah, the fundamental is the ownership never changes hands. You always are the owner. Okay. CW, which really ties in with everything. They're sending you some flunky who doesn't know their butt from the hole in the ground, and naturally they're just doing what they're told to do, which is totally wrong. They don't know the law. So the final thing that when push comes to shove, which invariably at some level has to, you just gotta put your foot down, and, CW, yeah, alright. In the ground, someone has to put your foot down. CW, yeah, no use arguing with people because there's only one way. That's all they know until they're taught a lesson. You gotta take these kids to the woodshed and start beating their butts once in a while and maybe they'll start doing what they're supposed to be doing. So, would it be, a document that would be something like, say, a notice of withdrawal. CW, yes. To start it, yeah, that would get things started, wouldn't it? CW, alright. This is under, Corpus Juris Secundum, Book 10, page 166. This is out of, Bills and Notes. I believe it was. It says a piece of paper never ceases to be the property of the issuer. That's what? Corpus, Juris, Secundum. CW, yeah, Corpus Juris Secundum. Book 10. That's under bills and notes, and everything today is really a bill or a note. It's really doing commerce. Everything you put your paper to, assign a signature to, becomes a negotiable instrument, under debtor, creditor. So everything you ever signed is a piece of paper that never ceases to be the property of, or never leaves, never ceases to be the property of the issuer. Well, the issuer would be IRS in this case, wouldn't it? CW, no, number. Whoever signed the document is the issuer. UCC 3105. Okay. Now the promisor, the transferee, is the IRS, and they stand in a fiduciary confidential relation to us, and we would be the, I guess, party. CW, yeah, but in order for them confidential fiduciary relationship, it's got to be expressed, and we have never expressed it. CW, none of us know how to express it. Confidential express none of us know how to express it. We don't know how to do special deposit. It says here under signatures, under corpus juris secundum, it says generally, a signature may be made for a person by the hand of another, acting the presence of such person and at his direction or request, on with his acquiescence, unless the statute provides otherwise. A signature of this type becomes the signature of the person, of whom it is made, and it has the same validity as though written by him. This mode of signing is sufficient for a sealed instrument, and even though the party affixing the signature does not have authority to do so, under seal. So, you know, right, we stated it, that basically what? Right? Signed for us. CW, yes, right. And every document that they got that they signed for him, same thing, is also still yours. Now you know that. The IRS has the rule regulation where they think they can sign for us too. CW, they've got all the power because under a general deposit title gets transferred to them. I see. That's what's giving them the power to. CW, yes. Withdraw the titles. The papers that gave them the power, they have no power, and then redeposit it under special deposit and put yourself on the private side, and then you will never reveal your identity by name, boundary, because you're private. What would be an instrument to do something like that? CW, well, it's really simple. But the problem is that nobody has enough basis of knowledge that they can say, oh, man, this ain't hard at all. People always thinking it's a simple document, but it's more of a process, right? CW, yeah, it's a process, but it's really a simple document. Yes. A series of documents. It's more than one, isn't it? CW, well, it could be. I could make it more as complex or as easy as I want it. And then you still have to operate it though. It's like, I guess what you're getting at. CW, yeah, you got to rebut it. He who fails to introduce any other evidence to rebut the presumption of authenticity, which attaches to a signature, then the party claiming under the signature will prevail. However, if a party denying a signature's validity introduces evidence sufficient to overcome the rebuttal presumption of the validity, then the case will be tried upon all the evidence introduced at trial. So, anyway, this establishes affecting this by a preponderance of evidence. So, it falls under, how to state claims, then. CW, yes, that's under corpus juris secundum, under signatures, section 16. Burden of proof. All these classes are well worth their time and effort, Christian. CW, yeah, it's all about the identity. That's the essential thing. It's not the name. The name, the boundary, the publicity, which is the public, or the privacy, which is the private, establishes, is one method of establishing the identity. So it's name, boundaries, and public. Those are the three that are going to establish the identity. This process that you're talking about, the IMF, that is a big block in another process where go for whatever, I guess what is our endeavor, and that is private. This is it right here. This is the block. CW, yeah. But nobody know how to be private. Nobody knows how to operate in private. If you were just handed documentation that says file this and now you're private, I'll guarantee you, when you walk out on the street the next day, you're gonna make yourself public. Sure. Yes. CW, you're going to crash everything that was done for you, because you do not know how to implement it. You don't know how to administer a trust. There is no use me giving this stuff to anybody, unless they understand it. You will crash it in 30 seconds. can't give the keys to a Ferrari to a 13-year-old. He's not competent to drive it. He'll wreck it. S, for lack of understanding. CW, yes. We're in this mess all together, because we've been foolish. We've been dumb. We keep on thinking doing the same thing tomorrow will achieve something different than we've done yesterday. We're all fools. We keep on going down the debtor-creditor rabbit hole, achieving something different tomorrow, which never happens, by doing what we did yesterday. It'll never work. We're perishing for lack of knowledge, and it's until everybody gets the knowledge. Most people don't want to handle this stuff. They're better off being slaves. Yeah, well, you know. The children of Israel, when they left Egypt. CW, yeah, they liked their leeks and onions better. They wanted to go back. Yeah, CW, like a dog to its vomit. S, it's a balance between people getting, I find, confused between assertiveness and aggressiveness, and, I always tried to differentiate it, because it helped me, when I go into a court or any other kind of a challenge, and to know that very clear line between asserting yourself and aggression, because that's one of the games a court plays. As soon as you get past the level of assertiveness and you touch on something aggressive, then that's your controversy and, contempt, and so on, right? Because they're always trying to get that track. CW, right. S, that's part of that. In public. Just to, just to add to argue what I stated earlier is that, once these, particular people, left Egypt, they wanted to go back, but the reason they didn't, was, because the water was there. They didn't know how to cross that, so it's like, once you go to the private, you better stay there. CW, yeah. God had to block their way of going back, or else they would have gone back. Yes. S, that's an interesting logic that would hold. But we've just been brainwashed, guys, and now we're just, putting back our pieces together. S, I wouldn't say brainwashed, but conditioned. It's funny when you got bad habit and then you're trying to break it. That's a more accurate kinda way of looking at it, like it's just because of conditioning. Brainwashing is like when you have no clue, two separate states of consciousness they're conditioning, it's just a bad habit. You gotta break it. It takes effort, will and concentration, and, you gotta, focus your whole, like a diet or quitting smoking, or something like that. Just because that's what people are doing. They're so conditioned. They got so much of one habit and so little of, starving for the other, and so that they can only do that. So you can't change a habit until you replace it with another one. That's one of the principles of it, by the way. So it applies here too. CW, well, we all have special drawing rights and special drawing rights are special deposit. Everything we have is special, but unless you express it to be special, you don't have any rights. He who sleeps on his rights has no rights. So wake up, sleepers. We've got all the right, unalienable by God, given to us by the Declaration of Independence, through, or the notification of it. I mean God gave it to us, but we just needed to wake up and, start asserting those rights and we can. It's simpler than we thought. Since we have our declaration, what does Ireland have? CW, I don't know. They're like, Canada has their claim of right, and I think it's kinda based on, constitutional, is a coronation of oath. S, I was just wondering, what foundation? Every country that's involved with the IMF has to have a foundation somewhere and CW, well, that declaration was just what it was. It was a declaration saying that we had those rights. Everybody's gotta have something. If they don't have it, they can still declare it. Garbled. CW, go ahead. A real trust or right. The ancient. Live man. So, I suppose, if they don't have a declaration and they don't have a claim of right, they'll have that one book. CW, that brings up the when the train run the freest, when it's crashing down through into somebody's house, or when it's running on the track. On the track. CW, yeah, on the track. And the Bible is that track. When it's running on the track. CW, it's restricted to the track. But that's what makes the train run the freest. Ancient writings. I believe the term the Bible has been trashed around so much that even young folks don't even have a clue what it is. You know, where did it comes from and start referring to ancient writings. A little bit of a picture that, they're old, very old. You know, I'm not trying to correct no one. That's just what I do with young. May do for others. CW, yeah? There was a lady coming on there, who wanted to ask question. L. Oh, hi, thanks. I recorded most of it. My recorder ran out about 20 minutes ago, but you guys. The whole, Declaration of Independence thing. I've got like 7 certified copies. I know. A gal was able to get hers apostilled by Hillary or somebody. burden of proof is on you. G. CW, you're the one claiming trust, so where is your proof that you got a trust? You have to create the evidence. I need some records, otherwise we have a debtor-creditor relationship here. We got a general deposit, not a special one. Anybody else? Comments? Questions? At 2 hours, 37 minutes, 35 seconds. T. A. Christian. I have a question. CW, yes, who's this? T. I'm Terry. I'm calling from Cyprus. CW, sure, go ahead, Terry. T. What I've done is I've declared a trust by taking a balance payoff statement for a mortgage and, claiming that as the asset title. I sent it back to the bank and, they've acknowledged it, but I sent it directly to the CEO to do it as a private trust. He's got their legal department to respond to the actual process, and they seem to be accepting that there is a trust in place, but they are saying that the administrator is not authorizing the conversion for the special deposit. CW, T, and I'm wondering, is there something that I'm missing in relation to the fact that they seem to be saying that they accept there is a trust, but there is no conversion taking place? CW, have you ordered them to do the conversion? T, I'm sorry. CW, have you ordered them to do the conversion? T, no, I haven't, which I'm wondering. They wouldn't do it. They wouldn't do it on the face value of it being declared a special deposit from the actual title, I take it. CW, you might try to give them an order first, and see whether or not they'll do it. T, I'm going to. Actually, I've sent out an amendment to the initial indenture that I sent with with the asset title. CW, order them to do the conversion if necessary, otherwise extinguish the debt. T, okay. Fantastic. CW, or order the extinguishment of the debt in order conversion if necessary. T, I will do that, Christian, thank you. They've made reference to an administrator, not authorizing. Are they referring to the trustee? CW, well, administrator, that's more of an agency relationship, other than trust. T, because they said the administrator has to authorize the conversion. CW, okay. Does the administrator have the authority? That's the point. Have you given them the authority to do the conversion if necessary, or to do the extinguishment of the debt? T, okay. So the administrator could be deemed to be the settler. CW, no, not the settler. I don't know how you're playing this, but who's the trustee? T, okay. What I've done is I've declared it in the private with the, CEO of the bank being the trustee, myself being the settler, beneficiary. CW, okay. So the bank is trustee and the bank is saying their administrator can't do the conversion. T, correct. They're saying that the conversion has to be authorized by the administrator, and there's only 3 parties in this trust that are involved, and 2 are me, obviously. CW, well, you could write them back a letter and ask them, does not the trustee have trustee position and does not the trustee have authority and is not the trustee the administrator on the trust here? And, do you have all the documents necessary to effectuate, an extinguishment of the debt? T, right, excellent. It certainly seems to be sort of 3/4 way there. They acknowledge that. They certainly seem to have acknowledged that there is a trust in place. CW, yeah, ask them the question, did they have everything necessary that they can effectuate what your purpose is? T, I will do. The other question I was going to ask is that I directed the trust straight to the CEO as a private man. He's got his legal department within the bank to respond. Would it be deemed to be a breach of my own trust if I was to speak to the legal department in relation to this matter? CW, no, I don't think so. Number. You could probably ask them. T, oh, okay, good. Then I could do that tomorrow, then. That's fantastic. That's the only question I have, Christian. Thank you so much and I'll let you know how that gets on. CW, alright. Thanks for calling. T, thank you. C, Christian. CW, yes. I got one question for you. For if I opened up an account, oh no, not if. I opened up an account a couple of months ago and I wrote on the application by grantor and without recourse. Would that establish a trust intent? CW, if you had the records that would be the manifestation of the intent. Then you could prove trust and, yes, it would be a trust. Oh, that's good. I'm doing something right. CW, but if you don't have the records to prove the trust, then you don't have a trust. No, I have I didn't get the originals because the bank, I think they're kind of. CW, this is where we get tripped up at, I think, is that we think that once we've done something, that's good enough. No, in their realm it's not good enough, because the only thing that they can see of the real man is when he creates a record. Everything else that the real man does, they can't see that. And just because you signed a document that is special deposit, that is trust trees, does not mean that they can actually see that. You gotta create a record of that and make a public notification so that they could see it. Right there, the one in CW, and the counties. And CW, yeah, in the counties. Because the only thing that they can see is in that realm is the manifestation of the real man's intent, and that is a record. If there are no records, there's no intent, even though you intended to be laughing. Yeah, well, getting to really fall into place, Christian, we're not as wise, as smart as you, but, you're making us get there. Hi, Christian, this is Jaime from California. How are you? CW, alright. How are you doing? Great, fine, thank you. I was hoping you'd touch a little bit more on the Segregation Trust. Earlier I received an announcement. Maybe you already covered this. I got on here late. CW, yeah, we don't have a Segregation Trust. Yeah. That's what the announcement says. It says you think you have a Segregation Trust. No, you don't. But, how does a Segregation Trust comes into play? I received an announcement. CW, we don't have a Segregation Trust. CW, well, it's really the heart of it, except the not one in existence until you've created, and none of us have created a Segregation Trust, so therefore there's no Segregation Trust. Well, that kind of goes in with what you said earlier just a while ago, where, if you don't have a record of the trust and you can't prove the trust, well, what better record than your own personal testimony or declaration out of your mouth at the moment? CW, yeah, but a real live man can't be heard in court. It's the record that speaks. I'm not so sure I buy that theory. I believe that once you're in an open court, on the floor of an open court, and the court recorder is doing her job, it's all being put on the record. CW, that's what I said. So if you speak that on and for the record you're in, so I don't buy that theory about the man not being heard in the courtroom. CW, well, as long as you establish your proper capacity in there, everything that you testify to, on and for the record, it's on the record. CW, yeah, that's it. Whoever makes the record, that's what speaks. That's right, so I don't buy the theory that the man can't be recognized in court. CW, look at him as a live man. He is the fiction. What does it mean when the judge says I can't see you? Because you haven't established a proper capacity. He figures you don't know who you are just yet. You haven't made the proper declarations. So how do you come in as man and make declarations? That's what he needs to do. No, first you gotta state friend on the record. For example, maybe come in as, and make a statement friend on the record. Say as grantor, beneficiary I'm appointing somebody here as a trustee to, with the authority to settle and close this matter. CW, and what happens when they disclaim? Then what? CW, what happens when that party disclaims? Disclaims? CW, yeah, yes, disclaims, refuses. Refuses. In order to refuse, it's got to be an express refusal, otherwise their silence is acquiescence. Garbled. If there's silence there and no rebuttal, then you confirm the record for and on the record, let the record show that my appointment stands. CW, yeah, if you can make the record, yeah, that would create the evidence. The proof that you would need to prove trust, yeah, if nobody rebutted it. J, yeah, it's, one of my best, my mentors that I've had privilege and many of us have. Some of us just don't know. Of learning from goes by the name Batman. Now, his basic philosophy is, the first thing that should come out of your mouth when, the judge calls the name of the straw man is I'm here for that matter as a friend of the court. And, the next statement would be there is a mistake. The next statement would be I have no proper notice. And the next step would be I trust that this matter will be settled honorably. And if there's no rebuttal to that, those statements stand for and on the record and then your silence and then you can basically go on to say in closing, being that there is no controversy here concerning me, it appears my business here is finished. Thank you very much. Have a nice day. And then you walk. CW, now what happens when issues an arrest warrant for the party named on there because they didn't show up? I agree. J, well, that's a little different issue. I'm referring to a scenario where you're in and you find yourself in the court. It could be construed that we don't know what they're gonna come out at you. And then you didn't have to. I'm thinking. J, so basically you went in there and established this capacity as friend of the court, without pointing fingers. It points out a mistake and you declare there's no proper notice. Means there's no contract or binding agreement between anyone or any meeting of the minds. CW, there is no contract. J, and so nobody is in there, and prosecution fails to rebut any of those statements. Where's the controversy? Without a controversy there is nothing to adjudicate. CW, well, first of all, they're coming in, you're coming in to do business as a banker and, you're either making a special deposit or you're making a general deposit. And if you make a general deposit you're gonna be the, debtor, and they're looking for the intent of the parties, and, if you're one of the unlucky ones that they issue an arrest warrant against, you'll have to handle that next. J, well, yeah, see we're already past the arrest warrant. We're in the court talking to the judge, we've been arrested or dragged in or have a notice to appear and we're in there. Did you want to have your own recorder? J, well, judging from the transcripts and horror stories I've heard, where the court recorders were manipulating the record after the fact. I mean I would always, notify the court that I'm bringing in my, digital recorder or my own private recorder or my own video camera. Yeah, J, and with written notice prior to showing up. And if they failed to respond in 3 days contesting that, or objected to that, then I'm coming in with my equipment. Recording equipment. Yeah, they'll try and stop you but, there's, exception rules, or whatever. I don't know how much equipment. But yeah, just basic recording, something like that. J, yeah, I'd like to come prepared to preserve my own record, just to compare with their record to see if they're, doing any hocus pocus after the fact that the record's transcribed and making adjustments to it. I've heard a lot of horror stories where that happens all the time, but sure, just the logic of it. Sure. Like. And get the records they recorded. J, yeah, right. I mean how possible is it that they can manipulate it? So basically it's like giving them notice. Trying to cover all your bases as far as that's concerned. Each jurisdiction has its own rules of court, specifically pertaining to them. Some might prohibit entities to give notice of it and you give it a notice of your intention, basically creating a trust indenture. And since an issue of having a portfolio of documents that are ready, but, that can only be presented privately, if needed. Is that right? CW, no, I'm still here. Okay, I just came back in. Can you guys hear me? CW, yes. Okay, It's a matter of having a portfolio of records. or the private presentation stuff? Are you referring to Batman's .s? Just the fellow who was talking and following his track of thought. So are you basically saying to create the necessary document? But I'm assuming that, and asking at same time that, we can't, interact directly, we can't make reference to them again. It's I see this, which reminds me. This is a better document of understanding and also how you act. This is everything, covering all your bases. CW, jurisdiction on them. It's through the identity of interests. It's Black's law. It says that the relationship between two parties, so let's say between the straw man and the real man, the relationship between two parties are so close that suing one serves as notice to the other so that the other may be joined in the suit. I never got this, but your straw man did, and they're so close as to the identity of interest that the other party got joined in without even knowing them. 9 out of 10 times they will not put a court recorder in the courtroom when you're the, and if you request one, it will be denied. No, unless you're the for, some heinous crime or some very large fine, then you'll probably get a court recorder. I mean just, And if you bring your own, expense. CW.j. Some places that I've tried that twice and I still paid the fine and went to jail. CW, yeah? It all depends on where you're at. Can offer a suggestion. CW, yeah, go ahead Herald. Saying about what happened. And so I've devised a little, so if it's possible to have someone to go with you that will take notes yourself immediately after the hearing. Affidavit based on your recollection of events. Be as specific as possible and get it notarized as soon as possible prior to you receiving the transcript. And if you see, major, differences, or omissions, then you go in and attach the transcript, and get your case dismissed based on that point alone, but you have to register yours first, and what I do also, I take that affidavit and put a self-executing agreement in it and present it to the judge and the opposing party, giving them 72 hours to acknowledge what it is, whether the recollection is accurate or not, and if they fail to so, it's deemed, an accurate record of the pleading. I've never had anything in the record was considered on appeal. CW, Harold, do you have a way of setting up so they can bring in your recorder? Well, like the gentleman was just saying, a lot. And I've dealt with quite a few jurisdictions. They really rebuff that because they're trying to protect what they're doing. CW, is there any kind of motions to put in or any kind of things we can put in too? Yeah, you could put in a motion ahead of time and, but like the guy said, I've seen a lot of those get denied, unless in the court rules. Right now? Yes, I hear you. Sorry about that. I must have gotten disconnected earlier. That was strange. As far as the motion goes, it's basically giving them the discretion. I can serve an administrative notice with a self-executory clause in it like Harold just suggested, as you did, with their, they're establishing the facts. The record of the proceedings. Earlier examples. Some notice of some sort of administrative intent. Getting their acknowledgement or their acquiescence and agreement by, a self-executory clauses. Whatever you want to achieve, put it in a self-executory clause, because you're never going to get them respond, to establish it. Yeah, I've never had. Became part of the record. On appeal. It was right there. If there's one thing I've learned, from dealing with Shane in New York, a cousin of mine in the San Francisco Bay Area, and reading many transcripts since 2006, trying to find solutions for court issues or criminal charges, and that is that, basically everything up until a trial, and even after the jury renders, a verdict, everything is, really, it's all these pre-trial really are private, opportunities for negotiation, opportunities for settlement, and offers and acceptance and counteroffers. Everything is just a presentment. So, it's always an opportunity to. So it's always an agreement. Settlement agreement, and so operating by law. So it's all by contract, and anybody that is in jail. Some justice once mentioned, was it a justice of some court, that whoever is in there is there by their own agreement. So it's all contract. Whoever ends up in jail is there by their own agreement. So we need to remember that it's always just opportunity to come to some agreement. CW, we're not entering the debtor-creditor realm. We're not doing contracts. We're coming under trust and we're allowing it to be enforced under the trust. What happens, Christian, is, everybody gets hoodwinked as soon as they get a notice to appear, a summons, a warrant, an indictment, and they think it's judicial. The whole thing is still administrative process. The opportunity. The whole thing. Administrative. To some agreement. In other words, really deploying all these court rules as far as the motion. Why not initiate a prior administrative process right there and then? CW, we're not doing debtor-creditor. We're doing trusts here. On this show we're doing trusts. I understand. And that's why I'm saying, when you're declaring, when you're expressing trust, with the authority to settle the matter, just expressed your trust verbally for and on the record. That's an administrative process right there. Motion. CW, if you haven't proved a trust, if you haven't claimed a trust, there is no trust. You're in debtor-creditor and you're back in with the same debtor-creditor people. CW, we're not attacking this as debtor-creditor. We're attacking this as trust. Exactly. And so at the moment you express that intent or declare that intent out of your mouth, those words are the trust. CW, no, you're bringing too much truth into the public side of the court and you're contracting over with, and you're waiving it all. That's what Shane did. Oh, absolutely. I wasn't supporting Shane at all on what he's doing. When I learned that everything is, up until the trial, is an opportunity for you to settle the matter, and that is by expressing the trust, and that's what you're doing. You're coming at it, and that's something, that I learned from all this. No matter how much paperwork you put into the court, it's all useless if you don't know, in what capacity you're bringing that in. CW, yeah, but I don't want to express the trust on the public side, because if I put too much stuff about trusts in there, I'm going to waive the trust. It's all privileged information I'm going to be spouting in open court, which will get it, it'll get it waived. Well, when you make a simple, basically you're establishing yourself as the grantor, establishing them as trustee or whomever, prosecutor, defender or even the judge, and then basically the trust property, or the res, isn't that the case itself? CW, right. And whatever outstanding issues and obligations of the case are, and liabilities that need to be settled. Trustee stands, fiduciary's responsibility to settle them. CW, yeah, that may be his responsibility, but I don't know if he will or not. But that's not the point. Can I enforce the trusts then? Do I have the necessary records created that I can prove the trust? Yeah, well, the biggest, we're going back to records again, and basically the biggest record is the one that's in your heart, and that's your intent. So the intent is, look, I know you guys are. You don't have to point it out to him. By just standing your ground and saying, is your intent, and the one question, why hasn't this matter? CW, why hasn't this matter? Why hasn't this matter? Why hasn't this matter been settled yet? If they come at you again, you just want to know who is going to settle this honorably. That's your biggest tool. Why do you need paperwork? You're forgetting one thing. In court, the judge, with a flick of his fingers, can get a list with your name on it. Your social probably. Because you're there for a reason and come out on an IMF sheet as a debtor. But there's ways to deal with that. That's why I keep trying to say, jurisdictions, standing, looking at documents that they present you. How to handle that? It's all the same thing. That's a separate component. Whatever charge they drum up, whether it's valid or trumped up, you say fine, I accept it. Now who's going to settle it? Because I want to know who's going to take responsibility for it. But it's certainly not it doesn't concern me, but if you want me to help you, I'm appointing whomever, is the next guy next to me here that's willing to settle this matter. Or if you want me to settle it, just tell me where I need to sign my acceptance to authorize these guys to go, ledger and close the accounts, because all we are is an agent. Authorized agent related to whatever trust account that's in existence, or whatever tracking numbers are in existence that the alleged, similar pseudonym is related to us from birth. S, some kind of, A, you know. That kind of knowledge should also get you off that IMF or these, you know. I'm not worried about any of that. They can track me all they want. They can track that account or their name all they want. It's their property. It's not me. Why are we even worried about those details? What I would like to know about is how can we gain control? How can we gain control of the unlimited ability, to access any resources, that we may need for our sustenance in our life, or to produce whatever we need? That's what I'd like to know. All the other stuff, we know that these accounts are there established and registered with the governments to make commerce viable, but they're not us. S, right. Well, we have some kind of relationship to them, that is our behavior activities. These accounts, gets back to that trust thing again. I mean, it's not some kind of relationship. That's the thing. Wrestling with. I know that it's not us in the sense I think you're saying. It's a record, it's a property, it's the documentation, and so on. The relationship is a trust relationship. I think you're right. And that is, that, if any issues ever come up and they try to attach any liability to me or you or Christian, or any one of us, the trust is when you express it. I trust that you guys will settle the alleged outstanding liabilities honorably. There is your trust. Yeah, and I think you're right. I think you're hitting it when you say, why hasn't this been settled? Because you're kind of expressing there's a lot of unspoken things. Exactly. Is that not a question when you ask that? Why isn't it settled? As the king. S, yeah, I don't mind that. It's been touched on, you know, that when it's been touched on. That's been floated before for sure. Christian. You go in camera hearing and you use this on the private side. CW, here's what I would have done. I would have set up the information records prior to, have them in court. And if I was going into court, the only thing I would be asking is why has it not been settled? Nothing about trust. Cause as soon as I express something about the trust, I'm going to waive the fact that I'm talking about the trust. I am to have the evidence and the records set up before going in there if possible. Otherwise, I can't talk about trusts. The only thing I can talk about is why hasn't it been settled? You act like it's already in place, and it always has been. Now in camera hearing, Christian. Now. Both parties. Or is this strictly dealing with the judge? CW, well, I could come in court and ask why hasn't it been settled? But then if he wants to get into it, well, how did you settle it? Well, that's protected and then we'd have to go into chambers and talk about that. Yeah, because when enter a motion for an in-camera hearing, the district attorney as well as the judge. Or would you in the just with the judge? CW, if the district attorney want to be there, that's fine. The trouble is he can't speak as a fiction. He won't be able to speak. The judge will probably shut him up. Well, Christian, will saying the word trust waive it? CW, yup. In open court you talk about trust, you've just waived it. When people are divorcing and they put in their decree, would that be waiving it? CW, now, if you want to talk about a statutory trust, that's a different thing. Because that is on the public side of the court. But I'm talking about the private trust. I'm going to use the case as trust trees and use it on itself to close it down by a trust. That, I can't reveal that kind of stuff in open court. Well, what kind of trust are we talking about here? You just waived it. Well, Christian, what about basically making a sort of an indirect statement in reference to a trust? CW, you could do that. When you're saying like, you know, I trust that this will be settled honorably, you know, it's in there. Already, go ahead. CW, yeah, and you can colorably say things like that, like in confidence, in reliance on, don't talk trust terms. Talk about portal words that would be considered in trust, but also would be considered in the colorable realm. Yeah, you could do it that way. But just don't bring the truth in that open court, because you'll waive it. Waiver is a privilege by voluntary disclosure under evidence rules. A party ceases to treat a matter as confidential, it loses its confidential character, right out of the evidence rules. So you can't even make reference, to the word trust even. Can't say that I'm operating in trust. Or anything like that. CW, well. I don't know. It could be construed either way. You're saying trust. Well, just what exactly do you mean, the judge might ask. What do you mean trust? When you're writing a letter and the ending salutation you usually to say something like thank you for your consideration, or, sincerely. I've been putting in there, just two simple words in trust, and then my signature down below by so and so for the, the all caps STUEK trust. CW, substitute in trust for in confidence, because that means in trust. In confidence, sure. CW, yup. Or reliance of, I like those. CW, alright, guys, it's getting kind of late. It's getting almost 20 after. Thank you very much, Christian. Blessings. Great call, Christian. ? Last comment. Sincerely. Does anyone know what that means? Sincerely means without seal. Laughter. It's Latin. Sins means without. Sincerely is without seal. Usually only used in private letters. Sincerely. Have you guys come across the word honor, what it means? What do you have? Well, off the top of the head, it deals with money, paying money. So, we always use, something in honor. There are 17 participants in this conference. It's a good word to look up because, see, when you go to court or watch it on TV, whatever, they call that person your honor. Well, they're really meaning that the word is you're paying the debt. Laughter, and we just didn't know it. Look up the word, guys, in a financial dictionary. Well, see, there's so much patriot misinformation flying around. You always hear never refer to Judge Your Honor, he doesn't deserve it, or some patriotic argument like that. The thing, you boil it down to, a real understanding, like it's based on some actual definition, and, it's like we got it all backwards. Is this call recorded, Christian? CW, yeah, until I drop off. Laughter. Alright. Good night, Christian. Have a nice Mother's Day. CW, alright. I know you've got a mom, or someone's mom. CW, thanks. Alright. You guys take care, and great call, guys. We need more intelligent questions and, counterpoints and stuff. CW, okay. Good night, guys. You really work for it. S, great call. Thank you, Christian.